Good evening, everyone. We're going to call the next case, which will be the case of Kangas versus Hammer. If I could have appearances, please, starting with plaintiff.
Good evening, Your Honor. My name is Phoebe Schneider, and this is my co-counsel, Nick Steverson, for your representation in today's case. Good evening. We also have entries of appearance.
Yes, you can approach.
After we have the parties enter their appearance, we're going to do some brief opening remarks. Thank you.
Thank you. And appearances for the defendant.
Yes, Your Honor. My name is Nell Tooley. This is my co-counsel, Morgan Murphy. We represent the defendant in this case, Dr. Jody Hammer. We also have a written order of appearance, if I may approach.
You may. Thank you. We'll start with some remarks from the court bailiff.
Thank you, Your Honor. Just wanted to thank you all. My name is Michael Kerrigan. I'm the youngest son of Judge Jim Kerrigan. I'm joined here by my mother, Bev Kerrigan. And in our father's legacy, we want to thank you for all participating tonight. When my dad passed, fittingly, his memorial service was in this very courtroom. Because although he had 6 kids, his 7th child really was this law school. He loves, his great loves were beyond his family, were this law school, trial lawyers, which means all of you, and also juries. So his only disappointment tonight would be that there's not a jury. But he would be so proud of all of you. And although he was a very accomplished jurist, he always wanted to make sure we recognize the humanity in our adversaries. And so he would start out every court proceeding with Judge Kerrigan's local rule 1A, and every counsel had to tell a joke to break the ice. I won't ask you to do that tonight, but I thought of that because of tonight's facts. And I think he would have made some very good puns about tonight's facts. But thank you so much for your participation, for all you do. I am a proud graduate of this law school. I'm a Regent Emeritus, and I'm really proud to see all of you. And thank you, my good friend, Justice Samore. He and I practiced together. And Judge Bakke, she and I practiced together when I was an intern. And Carolyn Fairless, who has been a good friend and helps out our law firm a lot. So thank you, and good luck to all of you. Thank you, Emily.
Good evening. Welcome to the final rounds of the 2021 Carrigan Cup competition. This is Colorado Law's premier student mock trial competition. My name is Emily Horowitz, and I'm the Director of Experiential Learning here at Colorado Law. This competition is made possible every year by the Kerrigan Endowment, which was established by the generosity of Judge Jim Kerrigan, his wife Beverly, and their children and friends. We are very honored to have Bev and Michael Kerrigan here with us today. The Kerrigan Endowment supports the annual Carrigan Cup competition, provides valuable financial awards to the student finalists, and supports the law school's mock trial team, which participates in several external mock trial competitions throughout the country each year. On behalf of the law school, we would like to thank the Kerrigan family for their generous and continued support of our law school. This past weekend, 11 teams, 22 student attorneys, competed in a series of mock trial competitions rounds to select the 2 most outstanding teams. These finalists will showcase their skills with us today. The student finalists for this year are Phoebe Schneider and Nick Steverson for the plaintiff, and Morgan Murphy and Nell Tooley for the defense. We thank the practitioners in the Denver, Boulder metro area who served as judges for us this weekend for the preliminary rounds. Thank you also so much to our Kerrigan competition chair, Evan Smithers, for his hard and outstanding work in making this event possible. And thanks so much to Jackie Cohen, our program assistant, and our wonderful events and IT departments. Without them, this event would not be possible. Each year for the final rounds, we welcome a distinguished panel of judges. We are so honored to have 3 outstanding members of our legal community serving as judges today. We have Justice Carlos Samore Jr. from the Colorado Supreme Court, Judge Ingrid Bakke from the 20th Judicial District, and Carolyn Fairless from Wheeler Trigg O'Donnell. We know that Judge Kerrigan would be proud of the accomplishments of these students today. We thank the Kerrigan family and friends again for their wonderful support of our law school. Good luck to everyone participating tonight. Thank you.
Thank you. Counsel, any preparatory motions that we need to hear before we get started with the trial?
Yes, Your Honor, we do have a few housekeeping matters. First of all, we would like to inform the court of our witnesses' pronouns. Ms. Cory Kangas' pronouns are she, her, and Dr. Andy Little's pronouns are he, him. Second, we would request that all witnesses, with the exception of the natural parties to the case, Ms. Cory Kangas and Dr. Hammer, be constructively sequestered pursuant to Rule 615A.
Any response to the request for witness sequestration?
No, Your Honor, we would also request that our witnesses be sequestered under Rule 615.
The motion is granted. All witnesses will be sequestered other than the parties to the case. Anything else from the plaintiff's side?
Yes, Your Honor. Next, we'd like to bring to the court's attention a judicial admission from the defendant's answer. Specifically in paragraph 5 of the answer on page 6 of your packet, the defendant admits in the first sentence of paragraph 5 of the complaint, which is on page 3 of your packet. In other words, the defendant has admitted that Judge Kangas, the decedent in this case, visited her clinic, on April 27th, 2008, and was seen for medical treatment by the defendant.
A response to the request for judicial admission?
No, Your Honor.
That request is granted. Anything else?
Yes, Your Honor. We ask that we be able to refer to exhibits as they've been pre-marked, exhibits 1 through 10.
Any objection?
No, Your Honor.
That will be fine.
And Your Honor, we prepared a PowerPoint to display during closing arguments containing testimony, exhibits, and jury instructions, and we ask for permission to use that. We've shown this PowerPoint to opposing counsel, and they have no objection.
And with no objection, that will be permissible.
And lastly, should we ask to constructively approach or assume that we are out of hearing of the jury?
You should assume that you're out of hearing of the jury for these purposes.
That's all housekeeping matters for the plaintiff, Your Honor.
Any housekeeping matters for the defense?
Yes, Your Honor. We'd like to draw the court's attention to the fact pattern that lists the dates of the case being the year of 2008. And we've continued to use the dates even though we're currently in 2021. So just to draw the court's attention that when we speak, it's as if we were in the early 2000s.
Understood.
I'd also like to draw the court's attention to the PDF page 12. The autopsy report identified as Exhibit 3 is an official public record under the Federal Rules of Evidence 8038 and is authentic.
Any objection to the authenticity of the autopsy report?
No objection to the stipulation as a public record. Your Honor, we do have a motion in limine regarding this document, but we have no objection to that particular stipulation.
So as far as the authenticity of the autopsy report, that's stipulated. Anything else?
Yes, Your Honor. We request that the jury's instructions be constructively read before closing arguments.
Any objection to that?
No, Your Honor.
That request is granted.
We would also request that our witnesses be constructively sworn in.
Any objection to that?
No, Your Honor.
That request is granted as well.
We would request that the witnesses keep time.
No objection.
That will be fine also.
Your Honor, we'd like to draw the court's attention to the pronouns of our witnesses. Dr. Jody Hammer is she, her, and Investigator Walker is she, her.
Understood. Thank you.
We would like to request or ask kind of your comfort level on masks. If we are speaking, if we're able to take our masks off, as long as we maintain a 6-foot distance.
Justice Samore, Judge Bakke, any objection?
I have no objection.
No objection to your removing your mask.
Your Honor, in relation to that, we ask whether or not we're allowed to move about the ball.
Yes, you may do that as well.
And then finally, Your Honor, the parties have stipulated that Exhibit 6 is admitted.
Okay, with that stipulation, Exhibit 6 will be admitted. So you can refer to it as an admitted exhibit.
Thanks, Your Honor.
Anything else as far as preparatory matters?
Nothing further from the defense, Your Honor.
I understand the plaintiff has a motion.
Yes, Your Honor.
You can proceed.
First of all, Your Honor, the plaintiff moves to exclude any opinions listed on Exhibit 3, the autopsy report, from evidence as to the cause of Judge Kangas' death pursuant to Rule 702. Under Rule 702, a witness that is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion if that opinion is based on relevant facts and data, if it is based on reliable principles and methodologies, if the witness relied on those methodologies, and if they have technical knowledge that would help the trier of fact understand the evidence. Here, the author of this particular document, Dr. Christine Stroud, is not testifying here today, and we do not know anything about her expert qualifications besides her title alone. And as such, we are unable to determine if she used reliable principles and methodologies while conducting this autopsy and coming to the conclusion as to what caused Judge Kangas' death. In fact, plaintiff's expert witness here today will testify to the fact that this autopsy appeared to be done sloppily and skipped a crucial step, that step being not dissecting Judge Kangas' heart. And as such, we do not know whether or not she did use reliable principles and methodologies, and ask that her opinion specifically be excluded, and that the doctors that are here testifying today that can be tendered as experts are able to come to their own conclusion based on this evidence.
Does that go more to the weight of the testimony rather than the admissibility, what you've identified?
Your Honor, we still believe that because of the fact that an expert witness here today will testify to the fact that this did skip a crucial step, the court must rely on, or the court, in order to accept expert testimony, must accept the fact that the expert relied on principles and methodologies that were properly used. And here, as we don't have any proof to that, but we do have experts that can testify as to the contents of this document, we ask that the opinion be excluded, as it does not take away from the rest of the document, but rather, because the cause of death is at issue in this case, the experts here today, rather than the doctor that we cannot elicit testimony from, testify to the contents.
And what about Rule 701? Is the testimony nonetheless admissible under that rule as fact witness testimony rather than expert testimony, given the role of the coroner who prepared the autopsy report?
Yeah, under 701, Your Honor, this testimony would still be required, would require specialized knowledge and education to come to the conclusion that this, to the cause of death of Judge Kangas, which is, I believe, blunt force trauma to the back of the skull, inducing an epidural hemorrhage. And under 701, this would not be lay witness testimony, but would still require specialized knowledge. And so under 702, we ask, because we cannot solidify and determine the qualifications of the expert, that this be excluded.
A response from the defense?
I have a moment to confer with co-counsel, Your Honor.
Yes, you may.
May I remove my mask, Your Honor?
Yes, you may.
Yes, Your Honor. In response to the plaintiff's motion in limine regarding the admissibility of the factual findings and opinions in Exhibit 3 to autopsy report, the response under 702 is that this report is a matter of public record published by an individual who has received an MD and is the chief medical examiner. In this situation, the chief medical officer has the authority and clearly technical knowledge in order to conduct an autopsy and to come to the findings of a conclusion. Additionally, in terms of the credibility and the decision of the jury to decide what was the cause of an individual's death, in this case, Judge Kangas, there is some contention over whether Judge Kangas died from a drop in blood pressure or from blunt force trauma to the head. Under 104E, this is a finding of fact that must go to the jury, and the jury is capable of weighing the weight and the credibility of the opinions listed in Exhibit 3 to make the determination. Additionally, under Rule 106, the party seeks to introduce only a part of a writing. The opposing party can seek to admit the entire writing under the idea of fairness. In this situation, we believe it would be unfair and prejudicial to the defense's case to admit only a portion of Exhibit 3.
Any rebuttal?
Yes, Your Honor, and while we do agree, may I remove my mask?
Yes, you may.
While we do agree that Dr. Christine Stroud is likely an expert, the testimony of another expert here today conflicts with how she conducted this autopsy. And while we do agree as to the authenticity of this as a public record and identify that this does have sufficient facts and findings in terms of the data, the opinions itself do not take away from the jury's ability to use this as and to determine the weight of this evidence and listen to the other experts here today opine on the actual cause of death. We also have prepared a redacted version of this document. If you would like to see that, that would show that it still encompasses the entirety of the factual findings of the autopsy report, with the exception of the final conclusion made by the doctor, but does not exclude any of the actual autopsy that was taken, and under Rule 106 would not implicate the rule of completeness.
I'm going to allow this to be admitted into evidence under Rule 702. I do believe that the issues that you've raised go to the weight of the opinions in the autopsy report, not the admissibility ultimately of those opinions. I do think that this would be helpful to the jury. The drafter of the report is a qualified expert. That's not in dispute, so I am going to permit that evidence. The motion is denied.
Yes, Your Honor.
Other motions by the plaintiff?
Yes, Your Honor. The plaintiff has one additional motion. Lastly, the plaintiff moves to exclude evidence of Judge Kangas' visits with other doctors, specifically a cardiologist named Dr. Murphy. For a bit of background, before Judge Kangas' death, before he saw the defendant, Dr. Hammer, he routinely saw a cardiologist named Dr. Murphy. And we would like to exclude this evidence under Rules 401 and 403. The defense has not raised any affirmative defense regarding Dr. Murphy's involvement in failing to warn Judge Kangas about a fatal drug interaction, and we expect the defense will attempt to admit this evidence to prove that rather than Dr. Hammer, this other doctor, Dr. Murphy, was negligent. And on page 48 of your packet, which has the jury instructions, there is no place for the jury to assign fault to Dr. Murphy. Under Rule 401, evidence is only relevant if it has a tendency to make a fact of consequence more or less likely. And whether or not Dr. Murphy, a doctor not involved in this case, failed to warn Judge Kangas of a fatal drug interaction has no bearing on whether or not the defendant, Dr. Hammer, failed to warn Judge Kangas of a fatal drug interaction. And moreover, under Rule 403, the court may exclude relevant evidence if the danger of confusing the issues substantially outweighs that of its probative value. Here, as the jury has no option to assign fault to Dr. Murphy, there is no probative value to including this evidence, but rather it is highly prejudicial, as it is highly likely to confuse the jury as to who is at fault for Judge Kangas' death. And under both of those rules, we ask that this evidence be excluded.
A response?
Yes, Your Honor. If I may have a moment?
Yes.
Your Honor, for a little bit of background, Judge Kangas was very secretive about the fact that he was taking Viagra. His wife, Cory Kangas, will testify that she did not know. that she attended a cardiology appointment with Dr. Murphy, who was a cardiologist that Judge Kangas had sought because he was afraid of having a heart condition. There, she will testify under statements made for medical diagnosis or treatment that Dr. Murphy did not warn Judge Kangas about taking Viagra and nitrates at the same time. Under 401, this is extremely important. It's relevant because it shows, more likely or not, whether or not Judge Kangas was forthcoming in the fact that he was taking Viagra. When Judge Kangas visited Dr. Hammer on April 27th, 2008, he filled out the medical form, Exhibit 6, that's already been admitted into evidence, and there was asked about the medications that he was currently taking. He did not list Viagra. And so in assigning fault as to whether or not Judge Kangas was responsible for his own death in not telling Dr. Hammer that he was taking Viagra, this really goes to assigning responsibility and contributory negligence to Judge Kangas. Additionally, under 403, in terms of confusing issues, there's no confusion here over whether or not Dr. Murphy is being sued. Dr. Murphy is not in the courtroom today. He will not be testifying. This is going to show kind of the alternative causes of death and whether or not any drop in low blood pressure could have been avoided had Judge Kangas been more forthcoming with the medications that he was taking.
So counsel, a question for you. What do you hope that the evidence of these visits with other doctors will show other than the fact that he was taking Viagra? What specifically is it that you think is the relevance of those visits?
Specifically, what's important about it is the severity and the concern that Judge Kangas had regarding his heart condition. The defense seeks to show that there are potential alternative causes of death, specifically blunt force trauma to the head, but additionally to show that had Judge Kangas been as concerned about taking his heart medication as the plaintiff is going to testify, that he would have shown to Dr. Hammer that he was taking that medication. Additionally, Dr. Murphy is the individual that prescribed nitroglycerin, and that those nitrates were found in the autopsy report. And so really to see kind of where that medication came from and just how serious the diagnosis around his heart condition was.
Is there any dispute, counsel, about the medication that he was taking and the dosage when it comes to the nitroglycerin?
In terms of the evidence that is available to both parties, it's really only listed in Exhibit 6, which has been admitted. It's the nitrates listed as needed.
A reply?
Yes, Your Honor. I believe that the testimony that my opposing counsel seeks to elicit with this response is improper character evidence under Rule 404A. Under 404A, evidence of a character trait is not admissible to show that a person acted in accordance with that trait on a particular occasion. Here, as eliciting that Judge Kangas failed to disclose his taking of Viagra on an earlier occasion just to prove that he might not have done it on a later occasion is an improper use of character evidence and not admissible. Furthermore, I believe that my opposing counsel would seek to use this to show that Judge Kangas was on notice from Dr. Murphy that he should not have been taking Viagra, and that argument does not work either because of the fact that if Cory Kangas, Ms. Kangas, the plaintiff in this case, is asked whether or not he had been warned about any drug interactions whatsoever, including Viagra, she will say that he was not warned by Dr. Murphy, and as such, this cannot go to his own contributory negligence as he was not on notice and we will not hear testimony from any witness today to prove otherwise. And as on the jury instructions, the only parties that fault can be allocated to are Rob Kangas and Dr. Hammer. There is no basis to include testimony regarding Dr. Murphy because once again, under 403, it will lead to jury confusion.
It's always difficult to make these kinds of rulings in a vacuum when we haven't heard the evidence yet. I'm inclined to grant the motion, but if something happens during the trial that opens the door to having this evidence come in, then I'm going to invite the defense to raise this issue again. But for now, I'll go ahead and say that based on what I've heard, it is not admissible, but again, I will let the defense make another go at it if the evidence comes in a different fashion.
We have no further motions, Your Honor.
Does the defense have any motions?
Yes, Your Honor. Your Honor, we request a preliminary hearing on the admissibility of Dr. Hammer's prior civil conviction. For context, in October 2001, Dr. Hammer was sued in another state in order to pay a patient damages for failing to warn the patient of the likelihood of unfavorable interactions between two medications. The prior conviction should be excluded for two reasons. First, Dr. Hammer's prior conviction should be excluded under 404A. Under 404A, evidence of a prior wrong or act is not admissible to prove that a person acted in accordance with that prior character. Here, opposing counsel will use this evidence for propensity purposes. The evidence would be used to show that Dr. Hammer acted in accordance with her prior negligence. The use of this evidence would distract the jury from the main question of what actually happened and would create an inference that Dr. Hammer should be held liable simply because of her past choices. Additionally, Exhibit 8 should also be excluded under 403. Under Rule 403, evidence should not be admitted if its probative value is substantially outweighed by its prejudicial effect. Even if the character evidence falls within the narrow exceptions of 404B, the evidence should not be admitted because it is unfairly prejudicial. The case at hand is a medical malpractice suit, alleging that Dr. Hammer failed to properly warn the deceased husband of the plaintiff of potential interactions between two medications that the husband took. Allowing evidence of prior conviction involving substantially similar facts would lead to unfair prejudice because it would arouse emotions in the jury that would lead to bias or hostility towards Dr. Hammer and would interfere with the jury's ability to reach an impartial verdict. Additionally, allowing the admission of Exhibit 8 or mention of Dr. Hammer's prior conviction would mislead the jury and confuse the issues. The issue at hand is whether Dr. Hammer was negligent in failing to warn Judge Kangas. Whether or not Dr. Hammer has a prior conviction for failure to warn would confuse the jury as to which facts are being used to determine liability today.
Response?
Yes, Your Honor, we do not intend to use any of this evidence. However, if opposing counsel intends to tender Dr. Hammer as an expert, then we ask under Rule 104A to be able to use this during voir dire only, but we will not introduce any evidence of this prior conviction.
I don't think that the evidence of the prior conviction is relevant. Even if it did, I find that the probative value would be outweighed by the prejudice, so I'm going to grant that motion. If they do try to endorse him as an expert, you can address the issue then of whether or not that should open the door. Any other defense motions?
Nothing further, Your Honor.
Any other preliminary matters from any of the parties?
From the plaintiff.
Plaintiff, are you prepared to do your opening statement?
Yes, Your Honor.
Yes, sir.
You may proceed.
Your Honor, may I remove my mask in the well?
You may.
Thank you.
And anyone who wishes to speak can remove your mask. You don't have to ask permission every time you do it. You have that permission going forward.
Thank you. May I proceed?
You may.
6 minutes apiece. 10 an hour, 120 a day. That's how the defendant, Dr. Jody Hammer, routinely saw her patients. Day in and day out, she'd go to her walk-in clinic, clock in, and wait for the revolving door to start spinning. Every 6 minutes, her staff would send a new patient through that door, and every 6 minutes, she'd send them on their way. For each one, 6 minutes to review their intake forms, their medical histories, to talk about their symptoms, to diagnose them, to explain that diagnosis, to prescribe them medicine, to explain that medicine, to check for side effects, to check for contraindications, to send it to a pharmacy, 6 minutes. And then on to the next one. My client's husband, Judge Rob Kangas, was one of those patients. Judge Kangas was sick, and he went to Dr. Hammer for help, and what he got was the same attention Dr. Hammer routinely paid to everybody else, 6 minutes. And a month later, Judge Kangas was dead. What Dr. Hammer missed in those 6 minutes was that Judge Kangas had a heart condition. He had a history of low blood pressure, and chest pains, and fainting spells, and dizziness. And he was taking nitroglycerin to treat his heart condition, which he wrote plain as day, on his intake form. Dr. Hammer doesn't even remember reviewing that intake form. If she had, she would have seen something else on him. Judge Kangas wrote that he had erections lasting longer than 4 hours. Now, you'll hear from Dr. Andy Little today, a cardiologist with 20 years experience and expertise, who will tell you there's only one cause of that condition. Only one cause of erections lasting longer than 4 hours. It's a drug called Viagra. Now, Viagra is meant to treat erectile dysfunction, but in patients with heart conditions, it can cause a rapid and severe drop in blood pressure. It can kill. Judge Kangas was found with Viagra in his blood. Now, Dr. Little has reviewed the medical records, he's reviewed the autopsy report, the toxicology report, and he knows the medicine inside and out, and he'll tell you Judge Kangas died from taking Viagra. Dr. Little will also tell you that Dr. Hammer, the defendant, should have seen that death coming. She got a form in front of her telling her that the judge had a heart condition, telling her that he was taking nitroglycerin, and warning her that he was taking a drug, Viagra, that could kill him. Dr. Little will say that if it were his patient, he would have grabbed the judge by the collar and said, "Judge, you have to stop taking Viagra right now. It'll kill you." Dr. Little will tell you that any reasonable physician would have made absolutely sure to the patient that their life was in danger. The defendant will admit to you she didn't do that. She only had 6 minutes. Now, today isn't just about the doctors. It's also about Cory Kangas. Ms. Kangas is Judge Kangas' widow and the plaintiff to this suit, but she's also the person who found him the day he died. She went to his office worried sick because the judge hadn't come home the night before, and what she found was the judge lying peacefully in his chair, his skin cold and gray. She didn't notice anything unusual about his surroundings, nothing out of place that she took notice of. She just found the judge lying in his chair, passed away. Remember that scene, the judge lying peacefully in his chair, when the defense puts their witnesses on the stand. We expect that we'll call an investigator named Stevie Walker to testify. And Stevie Walker is going to try and tell you that the judge didn't die from Viagra. Instead, Stevie Walker is going to tell you a murder mystery. He's going to tell you that when he arrived, the judge's head was covered in blood, and there was a blunt object, what he'll call the murder weapon, lying next to him covered in blood. But folks, Stevie Walker took photos of the scene. You'll see him today, and don't worry, you won't see any blood. You won't see the judge lying in a pool of blood. You'll see him lying peacefully in his chair. No visible signs of injury, just like Ms. Kangas said. And you won't see a murder weapon. You'll see a plain old trophy. No blood on it. If you listen carefully, you'll also hear something about Stevie Walker's personal relationship with the defendant. The defendant is Stevie Walker's personal doctor, and what's more, the defendant herself recruited Stevie Walker to follow my client around town, to look into my client's personal background. Now, you'll hear from the defendant today, and she'll admit she doesn't remember reviewing the judge's intake form. She'll admit she vaguely remembers seeing the judge at all. She remembers that he was lightheaded, but she'll admit she didn't ask him about his heart disease. She didn't ask him about his nitroglycerin or his fainting spells or his low blood pressure or his chest pain. She didn't ask about that. And she'll admit that she didn't ask about his erections lasting longer than 4 hours. She will tell you that she didn't warn the judge about Viagra at all. She didn't warn the judge about the dangerous side effects of that medicine. And then she'll tell you that the judge's death was his own fault. She'll tell you that the judge, the patient, should have known better than to take Viagra because The makers of Viagra occasionally advertise their medicine. She doesn't know that the judge ever actually saw those advertisements. So that's what she'll say. She'll try to pass the buck. And when she does, I want you to ask yourself, why do you go to the doctor at all? If you're supposed to get all of your medical advice from magazine ads, why do you go to the doctor at all? At the end of the day, my co-counsel, Phoebe Schneider, will come up here and she'll walk through the evidence with you. She'll show you that Judge Kangas died as a result of the defendant's practices. 6 minutes a patient, 120 patients a day. She'll show you that the judge died from taking Viagra, that the defendant had all the information she needed to warn the judge about Viagra, and that any reasonable physician would have warned the judge. Now, as the plaintiff, we bear the burden of proving to you that Judge Kangas died as a result of Dr. Hammer's treatment. Ms. Schneider will show you that we've met that burden. She'll ask you to hold Dr. Hammer responsible for causing the death of Judge Kangas. She'll ask you to hold Dr. Hammer responsible for the consequences of her relentless routine pace. 6 minutes a patient, 10 patients an hour, 120 patients a day. Thank you.
Opening statement for the defense.
Today, we have more questions than we have answers. This is a case about a sudden tragedy, a story that will be filled with twists and turns, a story not easily told. This is a tale of the tragic loss of Judge Kangas, of a death with unknown causes and countless possibilities. And why? Because from treatment to tragedy, there is only one person with the answers that we need today. And that person is no longer with us. That person is Judge Rob Kangas. I want to take a step back now to June 6, 2008. Cory Kangas, the wife of Judge Rob Kangas, settled in for another long night. Another night alone. You see, her husband had taken to keeping odd hours, staying out late until 2 and 3 a.m. Cory Kangas went to bed, but when she awoke, her husband still hadn't returned home. She became concerned, she called, she left voicemails, and when she didn't hear back, she walked down to the courthouse to see if she could find him. When she got there, the doors were open. She walked in, she made her way up the stairs to the judge's office, and when she got there, she found his door unlocked. She walked in, it was all a tragic sight. There, lying in a chair, was her dead husband. Now, noticeably missing from the story that I just told you, the day that Judge Kangas was found deceased, is our client, Dr. Hammer. And why? Because Dr. Hammer saw Judge Kangas over a month prior, on April 27, 2008, one time, for an appointment that Judge Kangas told her was about lightheadedness, which you'll see in the intake form that we speak about today. Today, opposing counsel has the burden of showing to you, by a preponderance of the evidence, two things. One, that Dr. Hammer was negligent in failing to warn Judge Kangas about a potentially dangerous drug interaction. And two, that Dr. Hammer was the proximate cause of Judge Kangas' death. In telling you the story today, it'll unravel in 4 parts, beginning with Cory Kangas. Cory Kangas will testify today that she didn't know all of the medications that her husband was taking, including Viagra. That she knew her husband suffered from serious heart conditions, so serious that he had quit exercising and it changed his life significantly. We'll then hear from Dr. Andy Little. Dr. Little reviewed autopsy and toxicology reports in reviewing the death of Judge Kangas. Dr. Little will testify today that there was Viagra in the bloodstream of Judge Kangas at the time of his death. And Dr. Little will also testify that the autopsy was missing something rather important, something that's at the heart of the issue today. Judge Kangas' heart had not been dissected. We'll then hear from Dr. Jody Hammer. Dr. Hammer went to NYU and Johns Hopkins and specialized in diagnostic medicine. As part of her specialization, she's able to quickly and efficiently work with folks who come into her clinic to provide a high level of care. She's working to expand access to care in a community that needs it. And while she does see a significant number of patients, that has never affected the quality of care that she provides. And you'll hear her walk through today her process for reviewing those intake forms and the questions she asks patients. Critically, though, she does need one thing from those patients. She needs them to give her all of the information, to tell her what medications they're taking and what conditions they're suffering from, to tell her why they're there that day. And Judge Kangas told her that he was there for lightheadedness. Finally, we'll hear from Ms. Stevie Walker, an investigator, who went to the scene where Judge Kangas was found and walked through. She'll share with you today that Judge Kangas was found with bruising and blood on the back of his head, a trophy with blood in the very room he was found dead, an office with an unlocked door. Today, we will have questions, and we will not have the answers that we need. The answers that we need to definitively say that Dr. Hammer was the proximate cause of Judge Kangas' death. We won't have the answers that we need to say that Dr. Hammer had failed to warn Judge Kangas, because she didn't know the medications that he was on to even provide that warning. Today, we're going to have more questions than answers. And while in the wake of tragedy, it is difficult to accept this, we cannot close our eyes to the truth. Today, there are more questions, and the only person with the answers, the only person who could clear this up, who could close this chapter out and give us the closure we so desperately seek, is not in this courtroom. The only person who could answer these questions today is Judge Kangas.
Thank you, counsel. Plaintiffs, do you have a witness?
Yes, Your Honor. The plaintiff calls Ms. Cory Kangas to the stand. May I proceed?
You may.
Good evening, Ms. Kangas. Before we talk about why we're here today, I'd like to give the jury a chance to get to know you a little bit. Can you please state your name and spell out your last for the record?
My name is Cory Kangas, Canas.
What do you do for a living, Ms. Kangas?
I used to be a court coordinator. I'm not currently anymore. That's actually how I met my husband. I was his court coordinator.
How are you involved in today's case?
I was married to Judge Kangas, and I'm the one that found him the day he died, so I'm the plaintiff in this case.
I'm very sorry for your loss. Please let me know if you need a break at all during this. But before we talk about your husband, before you found him, let's talk a little bit about him when he was alive. How long were you and your husband married?
For 15 years.
What was your marriage like?
It was a typical marriage. It had its ups and downs, but He was my best friend and we had 10 really good years together.
What do you mean when you say you had 10 good years together?
We found out he had some health challenges that led to some significant life changes for us.
Let's talk about some of those health issues. How did you know that your husband had health issues?
Well, I lived with him. We were married for a long time and he took his health very seriously, so I did too.
How familiar were you with his specific health issues?
Very familiar.
How did you become familiar with them?
Well, like I said, we were married for 15 years, so it's just part of any marriage.
What specific health issues are you referring to?
He had low blood pressure.
How did that condition affect your lives together?
He was really worried about having a heart attack, so that led him to change his life pretty dramatically.
What do you mean when you say he had to change his life dramatically?
In order to prevent a heart attack, he tried to eliminate all strenuous activity, no more running, jogging, working out, anything like that.
To your knowledge, was there anything else your husband was doing to protect his heart?
He took nitroglycerin occasionally.
Do you know why he took nitroglycerin?
It's supposed to help prevent a heart attack.
Did you ever see him take any other medications?
He took vitamin C sometimes, but that's it.
Do you know if your husband ever saw any doctors around the time of his death?
I know from this case that he saw Dr. Jody Hammer about a month prior.
Okay. Now, I know this again might be difficult, but I'd like to shift gears a little bit and talk about the circumstances under which you found your husband. When your husband was alive, were you familiar with his work schedule?
Yes.
How were you familiar with his work schedule?
Well, I lived with him, so I knew when he came and when he went, and he always stuck to a routine.
What kind of hours did your husband keep at the courthouse?
Lately, he had been working pretty late. He would stay often until 2 or 3 in the morning, but it's just because he was so hardworking.
Do you remember the night of June 6th, 2008?
Yes, I will never forget that night.
Why will you never forget that night?
That's the night my husband didn't come home, and the next morning is when I found him dead.
What did you initially think when your husband didn't come home?
It was very unlike him, so I was pretty worried. I tried to call him, but he didn't answer.
What did you do next?
I went to the courthouse because I was very worried.
When you arrived at the courthouse, were you able to get inside?
Yes.
What did you do when you got inside?
I went straight to his chambers.
What did you do when you arrived at your husband's chambers?
The door was open, so I just went right in, and that was when I found him.
What did you think when you saw him?
He looked like he was sleeping at first, so I was relieved, but then I got closer and realized something was off.
What, if anything, did you notice when you looked closer?
He still looked kind of like he was sleeping, but his skin was gray and a little unusual looking.
Let the record reflect I'm showing opposing counsel what's been previously marked as Exhibit 2. Permission to approach for purposes of identification?
Yes.
Ms. Kangas, I've just handed you what's been previously marked as Exhibit 2. What is Exhibit 2?
It is a picture of my dead husband.
Is this a clear and accurate representation of what your husband looked like the day that you found him?
Yes.
At this point, I move to admit Exhibit 2 into evidence and constructively publish to the jury as its authenticity has been stipulated.
Any objection?
Yes, Your Honor. Counsel failed to lay foundation where this photo came from or who took it. While Mrs. Kangas may be able to identify the party in the photo, there's no indication as to who took this photo or where it came from.
Objection overruled. The exhibit is admitted.
Ms. Kangas, what did you do next?
I tried to wake him up, but he wouldn't, so I panicked and I called 911.
Why did you call 911?
I couldn't get him to wake up and he felt really cold, so I could tell something was off.
What, if anything, did you notice about your husband's surroundings?
Nothing out of the ordinary.
What happened next?
That is when the police showed up and they began an investigation.
When they began their investigation, where were you?
I was there when they arrived, but they needed me to leave so they could work. They were doing their jobs, so that was when I said goodbye to my husband.
No further questions.
Cross-examination?
Permission to retrieve the exhibit?
Yes, you may. Thank you.
Mrs. Kangas, I want to begin by asking about your relationship with Mr. Kangas. Your husband was a judge.
Yes.
You spent time at the courthouse where he worked.
Yes, I used to work there
You visited him at the courthouse.
sometimes.
You knew other attorneys in the community and those who worked at the courthouse.
Yes.
You knew Kelly Taylor.
Yes.
And now I want to take a moment to speak about your relations in the community. You were involved socially with Kelly Taylor.
Yes, we're friends.
You knew him well enough to recognize his handwriting.
Yes.
I'm directing opposing counsel to what's been marked as Exhibit 4. Your Honor, may I approach the witness?
You may.
And Your Honor, I want to indicate that this right now is part of a two-part authentication process under 104B.
Thank you.
This is Kelly Taylor's handwriting.
It looks similar, yes.
This is Kelly Taylor's handwriting.
I think so.
One moment, Your Honor. It is your testimony to the jury today that you think this is Kelly Taylor's handwriting.
Yes. It looks like his handwriting. I think it is.
You took a deposition on this matter,
Yes.
and you were under oath during this deposition.
Yes.
Your Honor, I'm showing opposing counsel Cory Kangas' deposition, and I'm directing parties to its NTC 16 testimony 4, line 18 and 19. I'm going to provide the witness with a copy of this, and if you can read silently as I read it aloud.
Objection, improper impeachment.
Your Honor,
What does the testimony say?
if I may offer a burden of proof, it says, yes, that is Kelly Taylor's handwriting.
May I respond, Your Honor?
Yes, you may.
She testified that this does look like Kelly Taylor's handwriting. This was exactly what she said in her deposition. She did not deny that.
I believe she said she thought it was his handwriting. Is that correct?
Yes, I believe so, which implicates what she is saying. And when she was asked again, she said, yes, this looks like his handwriting.
I'm going to overrule the objection and allow it.
Please follow along as I read aloud. Yes, that is Kelly Taylor's handwriting. Let's move now to what you knew about Judge Kangas' medical conditions. You knew your husband had health issues because you went to an appointment with him.
Yes.
You went to an appointment with him with a Dr. Murphy.
Objection, Your Honor, we established in motions in limine that evidence regarding Dr. Murphy would be excluded.
Your Honor, if I may be heard.
Response?
Yes, Your Honor. So opposing counsel opened the door to this line of questioning when they indicated that Mrs. Kangas was aware of the judge's medical conditions and she was aware of his heart conditions. As part of that, these issues came in when she went to an appointment with him with Dr. Murphy. So that's how she was aware of these issues. We're introducing this line of questioning to demonstrate that because she was at the appointment, and that's how she had knowledge of that. So that door was open during the direct.
May I respond, Your Honor?
You may.
I believe the witness testified that she knows that because she had been married to her husband for 15 years, and as such, she was familiar with his medical history. She elicited no testimony regarding any doctor's appointments, with her husband to any visits, or any other doctors that her husband may have had aside from the defendant in this case. We did not open the door to any discussion as to whether or not she was present with him at any of those visits.
I'm going to sustain the objection.
Walking back now to the significance of your husband's health conditions. Your husband was concerned about having a heart attack.
Yes.
Objection, speculation.
I'm going to allow it. Go ahead.
Your husband kept nitroglycerin on him at all times.
Yes.
I want to speak with you a bit as well about your husband's regular work schedule. Your husband worked until 2 or 3 a.m. every Friday,
Yes.
and this was a recent change. This hadn't been the entirety of your marriage.
No, it's in the past couple of years.
And moving out your husband's line of work and the types of cases that he tried, your husband didn't come home because he was staying late to wait for a jury verdict.
Yes.
Your husband tried a variety of cases.
Objection, lack of personal knowledge.
I'm going to, well, go ahead and respond.
Yes, Your Honor. She's testified that she's been married for 15 years. I think it's reasonable that they have dinner time conversations about the types of cases, maybe not all the details, keeping things, confidential as needed, but it is reasonable to believe that he would come home and have dinner time conversations with her, that he's seen a variety of cases. And we've already know that she knows that he's staying late to wait for jury verdicts. So we know that they are having and engaging in conversations around the types of cases and that he is going through and listening to cases.
May I respond, Your Honor? Then I believe that I would raise an objection to hearsay.
And why don't you rephrase the question?
Yes, Your Honor. You knew your husband was working on cases on Friday nights.
Yes,
Those types of cases would have varied.
probably.
Your husband tried criminal cases.
Yes.
Let's walk through the morning you found your husband. You were able to walk into the building where your husband worked that Saturday morning.
Yes.
When you walked into your husband's chambers, the doors were unlocked.
Yes.
It was unusual for the door to be unlocked.
Yes.
No further questions, Your Honor.
Redirect?
Just a moment, Your Honor. No redirect, Your Honor.
Plaintiff, you may be excused. Ms. Kangas. The plaintiff may call its next witness.
Yes, Your Honor. Plaintiff calls Dr. Andy Little to the stand. May I proceed, Your Honor?
You may.
Good afternoon, Dr. Little. I'd like to give the jury a chance to learn about you and your qualifications. Can you introduce yourself to the court?
My name is Dr. Andy Little, MD.
What do you do for a living, Dr. Little?
I'm a medical doctor.
And how are you involved in today's case?
Cory Kangas asked me to look into the circumstances surrounding the death of her husband, Judge Kangas.
What formal education do you have?
Well, I received my undergraduate degree in biochemistry from the University of Lone Star. I then went on to medical school at the University Polytechnical Studies. I then completed a residency.
What did your residency entail?
My residency was focused on cardiology, and I completed that at Fargo General Hospital in Fargo, Oklahoma.
What did you do for work after your cardiology residency?
After my residency, I came here to Armadillo, where I've been a practicing physician for 20 years.
From your 20 years of practice here, are you familiar with the standards of care applicable to physicians in Lone Star?
Yes, absolutely.
And from your 20 years of practice, have you developed any specialties?
Yes, I focus particularly on EDS, which is erectile dysfunction syndrome.
How did you develop your specialty in erectile dysfunction syndrome?
Well, I've been working with a number of patients over the last 20 years and become very familiar with EDS and its symptoms, as well as the drug used to treat it, known as Viagra.
And aside from your actual medical practice, have you conducted any research into cardiology and erectile dysfunction syndrome?
Yes, I have conducted research on those topics.
Without going into details, have you reached any opinions related to your investigation into Judge Kangas' death?
Yes.
Again, without going into details, what topics have you reached an opinion on?
Well, I've reached an opinion on the cause of the judge's death, as well as the standard of care exercised by the defendant, Jody Hammer.
Have you applied your experience and expertise to evaluate the judge's cause of death?
Yes.
Have you applied your experience and expertise to evaluate the defendant's standard of care?
Yes.
Your Honor, at this time, the plaintiff tenders Dr. Little's expert in cardiology and erectile dysfunction syndrome to opine on the cause of death and on the defendant's standard of care.
Any objection to the tender of Dr. Little as an expert?
May I have one here, Your Honor?
You may.
Dr. Little, you did a residency in cardiology,
That's correct.
and that residency allowed you to form an opinion as to what was the cause of Judge Kangas' death.
I would say the residency, along with the skills that I've gained over 20 years as a practicing physician, yes.
And when forming your opinion, you reviewed the autopsy of Judge Kangas.
Yes.
And you were able to review it because you understand autopsies.
I understood enough from the autopsy, yes.
But you're able to review the autopsy because you understand the process of an autopsy.
Yes, I would say I understand how autopsies are conducted generally, yes.
And you understand autopsies because you've conducted extensive research.
Research on what exactly?
Dr. Little, you've conducted research on how autopsies determine different causes of death.
In some areas.
What is one of those areas, Dr. Little?
Focused on the interactions of cardio issues and Viagra.
And you wrote an article about cardiological autopsies as they relate to erectile dysfunction syndrome.
That's correct.
And that article was published in the New England Journal of Medicine.
The New English Journal of Medicine, I believe.
Thank you. No further questions.
Counsel, any objection to the tender of Dr. Little as an expert?
No, Your Honor.
He is accepted as an expert. You may continue with your direct witness.
Well, Doctor, now that we've learned about your qualifications, I'd like to talk about what caused Judge Kangas' death. What caused Judge Kangas' death?
Judge Kangas died as a result of the Viagra he was taking interacting with his existing heart condition.
Can you tell us a bit about Viagra?
Yes, Viagra is commonly used to treat erectile dysfunction syndrome, but in patients such as the judge, it can cause a dangerous drop in blood pressure and lead to death.
In your experience, should a patient with a heart condition take Viagra?
No.
Why not?
Well, because as I said before, the Viagra interacting with the existing heart condition can lead to that drop in blood pressure, and it can lead to absolutely catastrophic cardiac failure.
How did you reach your opinion that the judge died from taking Viagra?
Well, the judge had 30 milligrams of Viagra in his bloodstream at the time of his death, and that interacting with his heart condition would be more than enough to cause the cardiac issue.
Did you review records to form an opinion?
Yes, I did.
Which records did you review?
The autopsy report, the toxicology report, the intake form that the judge completed at the defendant's intake clinic.
Well, I'd like to talk first about what you learned from that intake form from the judge's medical records. How do you know that the form came from the defendant's clinic?
It had the defendant's name as well as the clinic in its letterhead on top of the form.
How do you know the form was for the judge?
Had the judge's name, the judge's birth date, the judge's medications, as well as the judge's listed symptoms and conditions on the form.
Would you recognize the form if you saw it again today?
Yes.
Showing opposing counsel will to agree to admitted as Exhibit 6, permission to approach.
Yes.
Doctor, I've handed you what's been previously admitted as Exhibit 6. What is Exhibit 6?
This is the aforementioned medical intake form from the defendant's clinic.
What did you learn about Judge Kangas' medical condition from reviewing Exhibit 6?
Well, I learned two very important things. First, I learned that the judge had a heart condition, and second, I learned that he was taking Viagra.
Well, we'll go through those in turn. What about Exhibit 6 indicated the judge had a heart condition?
Well, first of all, the judge listed nitrostat, which anyone in my profession knows is the trade name for nitroglycerin, which is commonly used to treat patients with a heart condition. The judge also listed that he actually was suffering from heart disease here by writing yes, and he also listed several symptoms, including chest pains, fainting, and low blood pressure.
We'll go to that second thing you mentioned now. What about Exhibit 6 indicated that the judge was taking Viagra?
Well, the judge listed here that he had erections lasting more than 4 hours, and that would be sufficient to know that he was Viagra.
Why would erections lasting longer than 4 hours indicate the judge was taking Viagra?
Viagra is the only cause of erections lasting longer than 4 hours.
Well, doctor, in your opinion, would Viagra be a safe drug for Judge Kangas specifically to take based on those disclosed symptoms?
No.
Why not?
Well, because of the judge's existing heart condition, and because of Viagra's known possibility to interact with heart conditions, the judge was walking a very fine tightrope and could have easily tipped over.
May I retrieve my exhibit, Your Honor?
Yes.
Well, since, Doctor, we know that it was not safe for the judge to be taking Viagra, I want to discuss what you learned from that autopsy report now. Would you recognize a copy of the autopsy report if you saw it again?
Yes.
Joint opposing counsel has been previously marked as Exhibit 3. Permission to approach for purposes of identification.
Yes.
Doctor, I've handed you what's been previously marked as Exhibit 3. Do you recognize Exhibit 3?
Yes.
What is Exhibit 3?
This is the autopsy and toxicology report that I reviewed when forming my medical opinions.
Is it in the same or substantially the same condition as last time you saw it?
It is.
This time plaintiff moves to admit Exhibit 3 pursuant to substantive stipulation 1, This is stipulated as a public record.
Is it a stipulated exhibit?
Yes, Your Honor, we're willing to have this admitted as long as it is the full, non-redacted version.
Exhibit 3 is admitted.
May we constructively publish to the jury as well, Your Honor.
Yes, you may.
Doctor, what, if anything, did you learn about the judge from evaluating Exhibit 3?
Well, I learned that the judge had 30 milligrams of Viagra in his bloodstream at the time of death, which I found to be significant.
Why did you find that to be significant?
Well, Viagra is a drug that metabolizes over time, and so if the judge had 30 milligrams of Viagra in his bloodstream, that would imply that he would have taken it just before his death. Otherwise, he would metabolize it.
Well, what, if anything, is the maximum dosage of Viagra you would allow a patient like Judge Kangas to take?
I mean, if you had to give me to a number, I would say at most 25 milligrams, but only if the judge was seriously counseled about the dangers of Viagra existing with his heart condition.
Well, going back to Exhibit 3, do you agree with everything in Exhibit 3?
No.
What do you disagree with?
Well, the medical examiner here opines that the judge died as a result of some blunt force trauma, which I disagree to as the cause of death.
Why do you disagree that was the cause of death?
Well, again, the judge had 30 milligrams of Viagra in his bloodstream. Doesn't really make any sense as to how that would end up there if he'd been hit on the head. And also, there's no clear indication of when this hit to the head occurred. It could have been hours ago.
Is your opinion that the judge died from taking Viagra consistent with the factual findings in Exhibit 3?
Yes, it is. Additional potential cause of death listed here are findings are consistent with fatal loss of blood pressure.
May I retrieve my exhibit?
Yes, you may.
Well, Doctor, since we know your opinion that Viagra killed the judge, I want to return briefly to the judge's treatment at the defendant's clinic. We spoke earlier about an intake form for the judge. Would a reasonable physician review that form before treating the judge?
Yes, any reasonable physician would review that intake form.
Would a reasonable physician review that form carefully before treating the judge?
Yes, any reasonable physician would review that form carefully.
Would it fall below the standard of care if the physician failed to review that form carefully?
Yes, it would fall well below the standard of care.
Why?
Well, because any reasonable physician would want the judge to understand you're taking Viagra, you have this heart condition. The combination of the two could lead to catastrophic consequences. It could lead to the judge's death.
And what medical information, if any, would a reasonable physician take from that exhibit, from exhibit 3?
Well, a reasonable physician would know that the judge had Viagra, or received Viagra rather, and with his existing heart condition, that could be absolutely terrible.
What medical advice, if any, would a reasonable physician give to the judge upon reviewing that form?
Objection, Your Honor, 407.
Response?
I don't believe that there's any subsequent remedial measure here, Your Honor. I'm not sure how 407 is implicated.
Yes, Your Honor. So in terms of the subsequent remedial measure, it would be here to show that if a reasonable doctor, the testimony will elicit that if a reasonable doctor had provided that kind of counseling, that this cause of death would have been it would have been avoidable, and that it was negligent in failing to give that warning. In this situation, it's speculative as to whether or not that actually was the cause of death, and the subsequent remedial measure of giving that warning can't be used to show that the doctor in that position was acting negligently.
I'm going to overrule the objection.
Doctor, I'll ask my question again. What medical advice, if any, would a reasonable physician give to the judge upon reviewing that form?
Look, a reasonable doctor would grab the judge by the scruff of his collar and say, "Judge, you gotta stop taking Viagra. It'll kill you."
No further questions.
Cross-examination.
I have a moment, Your Honor. May. Dr. Little, I want to start by talking about your involvement in today's case. You were asked to form a professional opinion about what caused Judge Kangas' death.
Yes, that's correct.
And in forming that opinion, you relied on a variety of documents.
Yes.
You relied on the Toxicology Report.
Yes.
You relied on the depositions of Cory Kangas and Stevie Walker.
Yes.
You relied on literature that you had regarding Viagra.
Yes.
You relied on your personal knowledge.
Yes.
Your personal knowledge includes your research.
Yes, I would say so.
Your Honor, I'm directing opposing counsel to what has been marked for identification purposes as Exhibit 10. Permission to approach, Your Honor?
Permission granted.
You wrote this article on autopsies as they relate to cardiological events.
Yes.
This is a reliable authority.
Yes.
Dr. Little, it is your professional opinion that, quote,
Objection. I'd ask that Exhibit 10 be read fully into the record and read into the record under the learned treatise exception before we start going into specifics. Constructively, I would ask that the whole article be read into the record.
Response?
no objection, Your Honor.
Okay. Go ahead.
Dr. Little, it's your professional opinion that this cause of death cannot accurately be determined without rigorous examination of the heart tissue itself and without a careful consideration of the blood chemistry. Given these new techniques and the increasing importance of good diagnostics in the medico-legal context, it is questionable to draw conclusions without dissecting the heart and doing proper blood chemistry.
Yes, that's correct, although I would say that I do believe in this article, it's been a little while, I wrote it several years ago, but I do believe I mentioned in cases without a clear explanation of death. And in this case, there was a clear explanation.
You formed an idea, you formed your professional opinion by looking at the toxicology report.
The toxicology and the autopsy, yes, that's correct.
I'm going to start the toxicology report. I am directing opposing counsel to what has been previously admitted as Exhibit 3, permission to republish, Your Honor.
Permission granted.
Permission to approach.
Go ahead.
This is the autopsy report that you relied on, Dr. Little.
Yes, the medical facts in listed I relied on forming my opinions.
In the toxicology report, they found that there was 30 milligrams of Viagra in the judge's bloodstream.
That's correct, they did.
The traces of nitrates were not quantified.
I believe that was what the medical examiner said, yes.
Dr. Little, I want to talk about the significance of this autopsy report. The autopsy found that Judge Kangas died from blunt force trauma.
Right, the medical examiners said that, but again, I rely more on the facts. I disagree as to the medical examiner's conclusions that were drawn from those facts.
Yes or no, Dr. Little? The autopsy found that Judge Kangas died from blunt force trauma.
The examiner opined, yes, that the judge died as a result of blunt force trauma.
The autopsy's anatomic findings was that Judge Kangas died from blunt force trauma.
I suppose you could say that, yes.
But Dr. Little, you concluded that Judge Kangas died from a drop in low blood pressure.
Yes, which is consistent with the findings in the report.
And you determined that he died from a drop in low blood pressure based on this autopsy.
Yes, based on the facts, not based on the opinion.
But you think that this autopsy was sloppy?
I do.
No further questions, Your Honor.
Redirect counsel?
Yes, Your Honor. May I proceed?
May.
Doctor, I want to ask you just a little bit about that article we read into the record a few minutes ago. I'm showing opposing counsel it's been read into the record as Exhibit 10. Permission to approach?
Yes.
Doctor, I'm handing you what's been read into the record as Exhibit 10. This is the article that you wrote?
Yes, it is.
And I believe part of that article says, quote, in cases without a clear explanation of death, one should never reach an opinion as to the cause of death without availing himself of the newest techniques. Did I read that correctly?
That's correct.
Doctor, was there a clear explanation of the cause of death in this case?
Without a doubt, yes.
What's the clear explanation of death?
The clear explanation of death is that the judge was taking Viagra with an existing heart condition. The Viagra caused his blood pressure to drop, and the judge went into cardiac arrest and died as a result.
Is that opinion consistent with the autopsy report we talked about earlier?
It is. The autopsy talks about the potential drop in blood pressure as resulting in the judge's death.
And is your opinion that the judge died from taking Viagra to a reasonable degree of medical certainty?
Yes, absolutely.
No further questions, Your Honor. May I retrieve my exhibit?
Yes, you may. Next witness for the plaintiff.
The plaintiff rests, Your Honor.
Any motions by the defense?
Yes, Your Honor. Under Federal Rule of Civil Procedure 50A, the defense moves for judgment as a matter of law, even viewing the evidence in the light most favorable to the non-moving party, in this case today the plaintiff. No reasonable jury could find Dr. Hammer liable under the circumstances established by the evidence. First, plaintiff has failed to show that Dr. Hammer acted below the accepted standards of care. The testimony put forth by Dr. Little today fails to speak to all of the actions that Dr. Hammer should have done in reviewing it and fails to get to the heart of the issue, which was her review of that medical document. Information that will come up during her testimony and is critical to proving that she was not liable. Second,
plaintiff has not proven that Dr. Hammer was the proximate cause of Judge Kangas' death by a preponderance of the evidence. Opposing counsel has failed to put on evidence today that would prevent any other causes during that month-long period leading up to Judge Kangas' death that could have been intervening or superseding causes of the death of Judge Kangas. For those reasons, the defense now moves for judgment as a matter of law.
Response by the plaintiff.
Your Honor, under Rule 50A, the court must take the evidence in the light most favorable to the non-moving party, here the plaintiff, and see if a reasonable jury could find for the plaintiff. A reasonable jury could find for the plaintiff here. We've heard from Dr. Little, an expert in his field, who has said that that Dr. Hammer should have warned the judge about taking Viagra, that any reasonable physician would have warned the judge, and that that Judge Kangas did in fact die from taking Viagra. That's negligence and proximate cause. We've satisfied our burden under Rule 50A, and this case should go to the jury.
Reply.
Yes, Your Honor. I'll re-raise some of the concerns that I raised, which is that Dr. Little has not expansively spoken to what the standard of care is, and Dr. Hammer is going to walk through her process to show that she was within the standard of care when she was providing care. She's going to walk through her process of reviewing the intake forms, as well as the conversations that she had with patients to show that she was acting within the standard of care. So by allowing her to move forward and present that testimony, that would allow a jury to have an answer, hopefully, to the question of at the heart of the case today.
As counsel know, the standard under Rule 50A is a very high standard. I do have to review the evidence in the light most favorable to the non-moving party here, the plaintiff. And if there's any evidence by which a reasonable jury could return a verdict in favor of the plaintiff, I must deny the motion. I find that the plaintiff has put on sufficient evidence through its expert witness, in particular Dr. Little, by which a jury could find, a reasonable jury could find, that there was a breach of the standard of care and that that breach caused the death of Dr. Kangas. For that reason, I'm denying the Rule 50A motion. Anything else before?
May I witness be excused, Your Honor?
Yes, my apologies, Dr. Russell.
Thank you.
Thank you very much. And I know we've been going for a little bit. Or counsel okay? Do counsel need a break?
Your Honor, plaintiff would request a brief 5-minute break. That's okay.
That is perfectly fine. Let's say 5 minutes.
think we have one, and then we should have another shortly.
Finance ready to proceed, whatever.
We'll wait a few minutes for them to arrive.
If you don't mind, if you're all right, I'm just gonna step out and see if I can go find her. Thank you.
That's a good idea, Council.
Luckily, no bail bondsmen were needed to be called.
Go, Sheriff.
I was planning on doing a bench warrant for witnesses around, so unfortunately, I'm not gonna be able to do that today.
It's getting late, I think we'll save you the time. Dr. Hammer, would you please state your name and spell your last name for the record?
Yes, Dr. Jody Hammer, Hammer.
And what do you do for work, Dr. Hammer?
I'm a doctor.
And where did you attend medical school?
I attended medical school at NYU in New York, where I graduated with honors.
Did you attend any other specialized schools?
I did a residency at Johns Hopkins, and there I specialized in internal medicine.
And now, Dr. Hammer, I want to move on to what you've been doing since you moved to Lone Star. What have you done for work since moving here?
I've opened up 2 clinics.
Why did you choose to open 2 clinics?
I chose to open 2 clinics because there's a need in Lone Star, especially in Armadillo, for affordable, accessible healthcare, and through my 2 clinics, I can serve a wide variety of clientele.
So you took the time to open up these 2 separate clinics. Let's walk through your decision. What's the pace of work like at the walk-in clinic?
At the walk-in clinic, it's very fast-paced. I want to make sure that my clients are not sitting in the waiting room too long. They come to an urgent care walk-in clinic for one fix, one urgent need, so I make sure that I get them in as quickly as possible.
And what types of individuals usually come into the clinic?
All types, really, and that's why I love working there so much. I see anyone and everyone in the community with all sorts of health needs.
Let's move now to how you met Rob Kangas. How did you meet Judge Kangas?
Judge Kangas came into my urgent care walk-in clinic one time many months ago.
Did you think much about it?
I did not. It was a very simple case.
So why did you think much about that appointment?
He just came in and he complained of lightheadedness. I diagnosed him with a sore throat, gave him the necessary antibiotics, and he was on his way.
So you make the judgment that Judge Kangas is suffering from a sore throat. From here, I want you to walk us through your decision-making process. How do you figure out a patient's illness when they walk into your clinic?
Yes, when they walk into the clinic, my front desk staff give them an intake form. They fill that out. Prior to seeing the patient, I review the intake form, and then I talk to the patient. I review their symptoms. I look at them and I diagnose them, and I prescribe the necessary remedy.
I'm directing opposing counsel to what's previously been marked for as Exhibit 6. Your Honor, I move to republish. And then I'm also going to hand witness Exhibit 6. Dr. Hammer, do you recognize this document?
I do.
And Dr. Hammer, I will walk through what information is provided on this document. What medications are listed on this sheet?
On this sheet, Nitrostat and Zovirax.
Are there any other medications listed?
There are not.
Would these medications cause you any concern?
No, they don't interact negatively with one another.
And finally, Dr. Hammer, let's take a moment to talk about what your appointments look like. Why do you ask patients to share what medications they're on?
I want to make sure that I have a holistic view of the patient themselves. I fully understand the situation that they're in, and I provide them the best care possible.
Why do you ask patients about the conditions they're suffering from?
because I want to be able to give a correct and accurate diagnosis, so I need them to be forthcoming.
Would you vary the length of your appointment if you heard about a serious condition?
Oh, absolutely.
Would you vary the length of your appointment if there were significant medications a patient was on?
Yes, if necessary, absolutely.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may, thank you.
Doctor, I'd like to start by talking about your walk-in clinic. You operate 2 clinics here in Armadillo.
I do.
One of those is a walk-in clinic.
Yes.
That's where you treated Judge Kangas.
Yes.
The walk-in clinic has established routines and procedures for seeing patients.
Yes, of course.
And you're familiar with those routines because you operate the clinic.
And own it, yes.
Yes, and you also participate in those routines when you treat patients there.
I'm the doctor there, yes.
You and the clinic follow those routines as automatically as possible.
Can you say it again?
You and the clinic follow those routines as automatically as possible.
In order for efficiency and proper care of patients, absolutely.
So yes.
Yes.
One of those routines is to review each and every patient's intake form.
Each and every one, yes.
You also set a routine pace for seeing patients.
I see patients as efficiently as possible, make sure they're not sitting in the waiting room too long.
I'm sorry if my question was confusing. You set a routine pace for seeing patients, right?
A routine pace in what way?
You try and keep it to about 10 patients an hour.
At the most fast paced, yes, I can see them in an hour.
So you try and keep it at 10 patients an hour.
If there are that many patients that need seeing, yes.
So yes.
Yes.
So patient every 6 minutes on average.
I could see that, yes.
You also keep a routine workday.
I do.
You work 12-hour days.
As most doctors, yes.
So in the course of a regular workday, you see 120 patients on average?
At the most, yes.
Well, since we've talked about you seeing 120 patients a day at the clinic, I want to talk about your routines when examining those patients. You'd agree with me, surely, that it's important to give every patient a thorough evaluation.
Absolutely.
It's important to make sure that nothing's wrong with them, right?
Well, something's obviously wrong with them. They're at the walk-in.
Sure. It's important to review their intake form, obviously.
Every patient, yes.
And it's important to review the medications that they're on.
The ones they disclose, yes.
And it's important to talk to them about those medications.
If it comes up in what they're at the urgent care for, yes.
And if it doesn't come up that those medications aren't part of what they're there, you would never talk to a patient about their medications.
If it was something that they were concerned about and if it led to their condition that day or I thought it could, I would speak to them about it.
Fair enough. And it's important to discuss the patient's symptoms with them, obviously.
The symptoms leading to why they're there that day, yes.
Okay. And to examine them.
Absolutely.
And to discuss why they're there.
Yes.
And to diagnose them.
With why they're there, yes.
And to explain that diagnosis to them.
Yes.
And to prescribe the medicine if they need it.
The medicine necessary for that day's diagnosis, yes.
And to check for side effects of that medicine.
Yes, so the antibiotics that I described to Judge Kangas, yes.
And it's important to explain those medications to each and every one of those patients.
Yes.
And it's important to actually send the medication to the pharmacy.
Yes.
And it's important to explain whatever the treatment plan is to the patient and answer their questions.
Yes.
You do that all in 6 minutes.
I do, if necessary, and if that's the pace that the clinic is at, and if I can efficiently resolve my client's issue.
Okay. Well, since we've discussed your routine of seeing a patient in 6 minutes, let's talk about one of those patients. You vaguely remember seeing Judge Kangas at your clinic.
Many months ago, one time, yes.
You didn't think much of it.
I did not.
Showing opposing counsel what's been previously admitted as Exhibit 6. Permission to approach?
Yes.
Doctor, I'm handing you Exhibit 6. This is the intake form that Judge Kangas filled out when he came to your clinic.
It is.
And you don't specifically remember reviewing this form before you saw the judge?
It is my standard to review each and every form for each and every patient.
And I'm sorry, I'm not asking about your standard. I'm asking you don't specifically remember reviewing this form.
Do I remember a single form from many months ago, one visit? Not the specifics, but I absolutely reviewed it.
So, but you don't remember reviewing that form?
Today, I don't remember specifically reviewing this form from many months ago, no.
It would fall below the standard of care if you failed to review that form, right?
It would.
Judge Kangas was lightheaded when he came into your clinic.
That was his complaint.
He also disclosed on that form that he had heart disease.
He disclosed on my form that he suffered from or he had a family history of.
Of heart disease?
Yes.
You didn't ask him if he personally suffered from it or if he had a family history of it.
It had nothing to do with his lightheadedness.
Lightheadedness has nothing to do with heart disease?
Not that day. When I reviewed him, I determined that he had a red throat. I then diagnosed him with a sore throat, gave him antibiotics, and that resolved the issue.
You didn't check him for a heart attack?
I did not check him for a heart attack for a simple complaint of lightheadedness, no.
You didn't ask him about his low blood pressure either?
I did not.
You didn't ask him about his chest pains either?
They had nothing to do with his lightheadedness.
You didn't ask him about his nitroglycerin?
It had nothing to do with his lightheadedness.
Well, despite him being lightheaded, you didn't take any of those steps. You didn't ask him about his family history or his present illnesses.
Sir, I run an urgent care walk-in clinic. He told me his present complaint was lightheadedness. I saw the issue before me and I resolved it accurately and reasonably.
If a patient comes into a walk-in clinic having a heart attack, do you have an obligation to review them for a heart attack?
If they're having a heart attack?
Yes.
Yes.
So, despite him coming in with lightheadedness, you diagnosed him with a sore throat?
That was what caused the lightheadedness.
Okay. Well, we've talked enough about how the judge came in with lightheadedness and left with a sore throat. So let's talk about what else the judge disclosed on Exhibit 6. Judge Kangas wrote on Exhibit 6 that he had erections lasting longer than 4 hours, right?
He answered yes to, do you suffer from, or is there any family history of?
You didn't ask the judge if he personally suffered from erections lasting longer than 4 hours, or if he somehow knew his family, someone in his family had erections lasting longer than 4 hours?
Well, those don't lead to lightheadedness, so no.
Okay. As a doctor, you understand that erections lasting longer than 4 hours can be caused by the drug Viagra.
Yes,
You didn't ask the judge if he was taking Viagra.
I did not.
You didn't ask the judge at all about his erections lasting longer than 4 hours.
I did not. It was not within the present complaint.
Okay. And as a doctor, you understand that Viagra can exacerbate heart disease?
I understand that it would be taken in conjunction with certain medication at the exact same time in a certain milligram it could.
So specifically, when you say that, you're saying, what you mean is that if a patient took nitroglycerin.
Your Honor, 701, this is an expert witness, or this is May I be heard, Your Honor?
Yes, go ahead.
Objection 701, so this witness hasn't been tendered as an expert to get into complex questions about interactions with medications, would go beyond her knowledge as a lay witness.
Response?
Your Honor, I'm following up on a question that the doctor volunteered herself. I believe in the interest of fairness, I should be able to explain the answer that she gave without me going down a road asking for expert opinions.
Any reply?
Your Honor, to go down this road would ask her to testify to specific knowledge that she wouldn't have as a lay witness right now. If opposing counsel would like to introduce her as an expert witness, then we would be comfortable with them laying the groundwork for that.
I'm going to permit the question to be answered.
Okay.
Objection overruled.
Doctor, I'll ask my question again. You mentioned a moment ago that if a patient took a certain medication and a certain dosage at the exact right time, it could exacerbate heart disease. What you meant was that if a patient took nitroglycerin at the same time as 25 milligrams of Viagra, it could be fatal, correct?
At the exact same time, and possibly it could be, but in very rare circumstances, yes,
It could be fatal.
it could be.
You didn't warn the judge not to take nitroglycerin at the same time as Viagra.
I didn't know the judge was taking Viagra.
So no.
No,
Okay. And you knew that he was taking nitroglycerin, right?
that is what he disclosed.
You didn't discuss Viagra with the judge at all.
I did not.
You didn't warn the judge not to take Viagra.
No,
You didn't warn the judge about any potential side effects of Viagra.
no,
You just diagnosed him with a sore throat and sent him on his way.
that was his present ailment.
No further questions.
Any redirect?
Can I have a moment for counsel?
Yes.
Dr. Hammer, let's return to your pattern and practice at the clinic. What do you do when you receive an intake form?
I fully review it before I see the client.
Would you say that's your standard of care?
Absolutely.
What do you do when you receive these intake forms and you see something noted under the family history and illness section?
I determine whether or not it might be a cause of that day's present ailment, why they are at the walk-in clinic, and if I think it could be an interaction, I would discuss it with them.
Would it be possible that someone could mark yes if it was just the family history?
Objection, speculation.
Response?
Yes, Your Honor. She's asking this question on a form that her clinic uses. I'm not asking her to speculate about really anything other than the fact that she uses this intake form and is eliciting an answer of either yes, they suffer from it, or no, they suffer from a family illness. So there's two options when patients mark onto this form, and she would know whether or not folks would use that second option.
I'm going to overrule the objection in the answer.
I'll ask you again then. Would a patient indicate with a yes mark under the line illness if it was a family history?
Yes.
And would it be dangerous to take certain medications at the same time?
Yes.
Would it be dangerous for someone with a heart condition to take Viagra?
If taken at the exact same time in certain dosages and in certain situations.
Would it be dangerous if a party weren't to tell you all the medications they were on?
If they were not to tell me, absolutely.
Would you be able to provide them with the proper guidance and counseling, the standard of care, if they didn't tell you the medications they were on?
No, I can't read their minds.
No further questions, Your Honor.
Thank you, doctor. You may be excused. Does the defense have the next witness?
Yes, Your Honor, the defense calls investigator Stevie Walker to the stand. One moment, Your Honor.
Good evening. Could you please state your name and spell your last name for the record?
My name is Stevie Walker. My last name is spelled W-A-L-K-E-R.
Thank you, Ms. Walker. And what do you do?
I'm an investigator for the Dallas County DA's office.
I want to talk a little bit about your role in this case. How are you involved?
I was asked to investigate defendant's death, so I showed up to his offices on the day that his body was found.
And what date was that?
That was June 7th.
And what did you see when you arrived at the courthouse?
When I walked into the courthouse, I saw Judge Kangas sitting in his chair. It looked as though he might have been asleep at the time, but rather quickly it became apparent that he was dead based on the color of his skin.
Was there anything you saw in the chambers that caught your attention?
Yes, there was a trophy lying at his feet with blood on it. He also had a nasty bruise on the top, the balding spot of his head.
And what did you do with the trophy?
I took it into evidence. I put on gloves to make sure that I didn't get any of my fingerprints on it, and then I put it into a sterile and sealed bag in order to safely and properly put it in evidence.
And did you run any tests on the trophy?
Yes, we ran a blood test on the trophy, and we found that that the blood on it matched Judge Kangas' blood type.
Objection, hearsay. Response?
Yes, Your Honor. Under, can I confer with co-counsel for a moment, Your Honor?
Yes.
Thank you. Yes, Your Honor. Under 8038, a public record is admissible if it sets out the office's activities as a matter observable under the legal duty to report, and in a civil case lays out the factual findings. In this situation, it's a blood report that was readily available in the office and is used for the factual findings in this criminal case.
I'm going to ask you to rephrase the question.
Yes, Your Honor. How did the results from the blood test impact your understanding of the investigation?
They led me to believe that the bruise on Judge Kangas' head could have been caused by the trophy.
Now, I want to talk about what else you saw when you entered the court chambers. Was there anything else that caught your attention?
Yes, there was some paperwork on his desk.
I am directing opposing counsel to what has been previously marked as Exhibit 4. Permission to approach, Your Honor?
Yes. Go ahead.
What is Exhibit 4?
This is the jury charge that I saw on the judge's desk. It's relating to a case that he was working on at the time.
And how do you recognize it?
It was on his desk during my investigation.
Is it a fair and accurate representation of the document you saw at the courthouse?
Yes, it is.
At this time, Your Honor, the defense moves to admit Exhibit 4 into evidence.
Any objection?
Yes, Your Honor, I object to hearsay and 805.
Response?
Yes, if you may have a moment, Your Honor. Yes, Your Honor. Under 803.3, hearsay is admissible if it is the declarant's state of mind. The plaintiff, Cory Kangas, had already authenticated Exhibit 4 and the handwriting of Kelly Taylor. In this situation, the declarant here is Kelly Taylor and speaks to the motive that Kelly Taylor might have in writing such a message. In relation to 805, any hearsay that would be involved would be the document underneath, and it's not assertive. It's not being used to assert anything in the case in the situation.
I believe this is being offered for the truth of the matter. It is hearsay, not subject to an exception. I'm going to sustain the objection.
Yes, Your Honor. I have one moment, Your Honor. Based on your investigation, what conclusions can you draw from the cause of death of Judge Kangas?
Objection under 702.
Response?
Yes, Your Honor. This is drawing on the knowledge of Stevie Walker after having conducted an investigation. It's speaking to her personal opinion, not in terms of anything scientific or technical, but just the basis of the opinion that she can draw after having been in the room with Judge Kangas.
Any reply?
Yes, Your Honor. Under Rule 701, a lay witness may only testify as to their rational perception. This question calls for the witness to go into the details of why she believes Judge Kangas died. That would require technical or scientific knowledge, which is an impermissible lay opinion under 701 and an improper expert opinion under 702.
This witness has not been endorsed or but it is an expert. I'm going to sustain the objection.
Yes, Your Honor. Just to clarify, Ms. Walker, where was the strange bruise on Judge Kangas?
It was on his head.
No further questions, Your Honor.
Cross-examination?
Just one moment, Your Honor.
Sure thing.
May I proceed?
You may.
Good afternoon, good evening, Ms. Walker. You work for the Dallas County DA's office?
Yes, I do.
You like working for the DA's office?
I do.
You like working for the Dallas County DA's office because you're not restricted by silly rules?
That among other things.
Is that a yes?
Yes.
Let's talk about your method of investigation on June 7th, 2008. You stated on direct examination that you believe Judge Kangas was hit in the head,
Yes.
and you came to this conclusion based on evidence you collected during your investigation?
Yes, I did.
Evidence that consisted of 2 objects
Yes.
and 1 photograph?
Yes.
You only have 1 photograph because you lost all other photographs?
Yes, but I was there myself.
You don't know how the photographs got deleted?
No, could have been a data corruption or something.
Okay. Let the record reflect, I'm showing opposing counsel what's been previously admitted as Exhibit 2. Permission to approach?
Yes.
Ms. Walker, I just handed you what's been previously admitted as Exhibit 2. This is the photograph that you took of Judge Kangas.
Yes.
This is the 1 photograph that we have of Judge Kangas's chambers.
Yes.
Okay. Now, because this is the only photograph that we have of the chambers following your investigation, let's talk about what you assumed from this photograph. In this particular picture, Judge Kangas looks like he's asleep in his chair.
Yes, depending on how you judge his power.
He's not laying on the floor.
No.
He's not contorted in an unnatural position.
No.
There's no blood in this photograph.
No.
There's no bruise showing in this photograph.
I believe it might be visible.
The judge's hair is white.
Yes.
We don't see any blood on his hair.
I see no blood.
Okay. May I retrieve my document?
You may.
Okay. Now that we talked about what's not there and what was not saved, let's talk about the objects that you did collect. You ran fingerprints. Is that
Yes.
correct?
Yes.
You ran fingerprints on a letter? Excuse me.
What's your objection?
Yeah, I apologize.
So goes to the direct exam.
I withdraw. 1 moment, Your Honor. Ms. Walker, I'd like to talk about the investigation, what you did outside of your investigation for the defendant. Part of the actions that you took in this case extended beyond investigating the judge's chambers.
Objection, Your Honor. This is out of the scope of the direct examination.
Response?
Your Honor, Ms. Walker testified that she was asked to look into the circumstances regarding Judge Kangas's death. This goes to what she did in response.
Any reply?
Yes, Your Honor. Let me start with the approach.
Yes.
Yes, so the opposing counsel is seeking to extract testimony that there is a personal relationship between Dr. Hammer and Steve Walker. However, this is out of the scope of the direct examination. During direct examination, Stevie Walker was asked to testify as to what she saw in the courtroom and what was done with the evidence within the courtroom, not the additional steps that she was asked to take outside or other parts of the investigation. So trying to lay any kind of foundation as to her personal relationships would be outside the scope.
Ms. Schneider will give you the last word.
Yes, Your Honor, this goes to the witness's bias, and bias is always relevant.
I agree that bias is relevant. I'm going to allow the question, but feel free to make another objection if you feel that she's going beyond bias.
Yes.
I'll repeat my question, Ms. Walker. Part of the actions you took in this case went beyond investigating the judge's chambers.
Yes.
You ran surveillance on a person named Mr. Taylor's house.
Yes, I did.
You observed his home on several occasions.
Yes, he was a murder suspect.
You never approached him, though.
No.
You never spoke to him.
No.
You also spied on my client, Ms. Cory Kangas.
As she was at his house, his private residence, yes.
Yes. You watched her go in and out of Mr. Taylor's home.
Yes, during the surveillance.
You watched her do this on several different occasions.
Yes, I did.
You weren't asked by the district attorney's office to do this.
May I refresh my memory?
Ms. Walker. Yes, one moment. All right, Ms. Walker, I'm going to ask my question again. You weren't asked by the district attorney's office to spy on Ms. Cory Kangas.
Objection, Your Honor. Status scope of the drug examination.
Your response?
Your Honor, this goes exactly to Ms. Walker's investigation, as she's already testified that she did run surveillance on a house following the death of Judge Kangas.
I'll allow it.
Ms. Walker, you were not asked by the DA's office to spy on Ms. Kangas.
I don't know.
You don't remember if you were asked by the DA's office to spy on Ms. Kangas?
No.
It's your testimony today that you do not remember being asked by the DA's office to spy on Ms. Kangas?
Yes.
Let the record reflect I'm showing opposing counsel what's been previously marked as Stevie Walker's deposition. May I approach for purposes of impeachment?
You may.
Your Honor, can counsel clarify what page number you're at?
If I may approach constructively.
Yes.
This is an impeachment by omission. There is no statement that she doesn't remember being asked. It's basically to clarify that she was asked by the defendant as opposed to the DA's office.
So since we're constructively discussing this, what's your response to the request to impeach this witness with that omission from her testimony?
May I have a moment to consult with counsel, Your Honor?
Yes.
Your Honor, I can point out the specific line that in which she does say who she was asked. One moment. If you turn to page 5, line 10.
No objection, Your Honor.
You may proceed.
May I approach?
You may.
Ms. Walker, is this the deposition that you made for this case?
Yes,
When you made this deposition, you swore to include all relevant facts.
I did.
Your attorney was there.
Yes,
I was there.
yes,
You had an opportunity to amend this deposition.
yes.
I'd like to direct your attention to page 5 of your deposition, line 10. Dr. Hammer is the one that asked you to spy on Ms. Kangas.
I was asked to look into her background, not to surveil her.
Okay. Dr. Hammer is your personal doctor.
Yes,
Dr. Hammer is the defendant in today's case.
yes.
No further questions. May I retrieve?
You may. Redirect.
Yes, Your Honor, I may have a moment.
You may.
Ms. Walker,
What did you see when you saw Judge Kangas in the courthouse?
I saw that he was lying, he looked lying in his chair, he looked very pale, and he had a bruise on his head.
And what did that bruise look like?
It looked nasty and odd. It was kind of on the peak of the bald spot of his head.
Was where he was bruised within the shot of the photograph that you were shown during cross-examination?
I believe so, yes.
I want to talk a little bit about those photographs. Why do you not have any other photographs besides that one?
They somehow got deleted off my phone or camera.
I'm curious, it was mentioned that you know Dr. Hammer. What is your relationship with Dr. Hammer?
I see Dr. Hammer in his office for yearly checkups. She's always been professional with me.
Do you have any relationship beyond those yearly checkups?
I have no personal relationship with Dr. Hammer.
No further questions, Your Honor.
Thank you. Ms. Walker, you may be excused. Does the defense have any additional witnesses?
No, Your Honor, we have no additional witnesses at this time.
Are there any matters that counsel need to take up with the court before we move to closing argument?
Yes, Your Honor. Defense counsel would like to re-raise our motion, judgment as a matter of law, under Federal Rules of Civil Procedure 50B, in the light most favorable to the non-moving party, and we believe that the evidence still has not. Counsel, or one moment. So under Federal Rules of Civil Procedure 50B, the defense moves for judgment as a matter of law, even viewing the evidence in the light most favorable to the non-moving party, in this case the plaintiff. There's no reasonable jury that could find Dr. Hammer liable under the circumstances established. There's still not been sufficient evidence outlined here today that would show that she acted below the standard of care, so no reasonable jury could find that she was liable in the case today.
Any response?
Yes, Your Honor. A reasonable jury viewing the evidence in the light most favorable to the non-moving party, the plaintiff, could, of course, find for the plaintiff here. We have heard evidence from Dr. Andy Little that it would fall below the standard of care if a physician failed to review the judge's intake form, that it would fall below the standard of care if a physician failed to warn the judge about Viagra, and that the judge did, in fact, die from Viagra. The defendant herself said that she doesn't specifically remember reviewing the judge's intake form. That alone is negligence, and it is also negligence that she admitted that she didn't warn the judge. As such, there is evidence that a reasonable jury could find for the plaintiff here. We should proceed to closing arguments and allow the jury to decide the case.
Your reply, Ms. Murphy?
Yes, Your Honor. You heard Dr. Hammer testify that it was a routine habit and practice to review those medical forms and to adjust the length of her appointments based on the conditions and the medical prescriptions that a patient was on. Additionally, you heard from Dr. Hammer that she would be unable to warn and properly advise a patient if she wasn't provided the full picture, specifically if she wasn't told all of the medications that a patient was on. So in the information that we've been provided today, we can see that Dr. Hammer acted well within the standard of care, and that her inability to provide additional counsel to Judge Kangas was due to the failure for him to provide additional medical information on the intake form provided by Dr. Hammer.
The jury may ultimately agree with you, Ms. Murphy, but for purposes of your Rule 50B motion, there is sufficient evidence here to send it to the jury. So for the same reasons that I denied the motion under Rule 50A, I'm also denying the motion under Rule 50B.
Yes, Your Honor.
Any other matters before we go to closing?
Your Honor, the plaintiff has a PowerPoint that we need to set up quickly if we could have a few minutes to do that.
Absolutely.
Thank you. Counsel, would you like to review our PowerPoint for facts outside evidence before we show it? It works. Amazing.
May I proceed?
You may.
Permission to move about the well.
Yes.
$6 minutes apiece, 10 an hour, 120 a day. That's how the defendant, Dr. Jody Hammer, saw her patients. That's how the defendant saw Judge Rob Kangas on April 27, 2008. Just like the other 120 patients that came in and out of the defendant's clinic on that day, when Judge Kangas came by, he filled out an intake form. He listed his symptoms, his medications. He waited to see the doctor. He explained those symptoms. But Dr. Hammer didn't treat Judge Kangas that day. Dr. Hammer didn't care for Judge Kangas, and when Judge Kangas left the defendant's clinic, he didn't get better. He came in with lightheadedness and left with a sore throat. And a month later, he was dead. Those are the facts. What the defense did today is try to come in and distract you from those facts by throwing out red herrings. And folks, you know what a red herring is. It's a distraction intended to mislead you, to take your attention from the truth. But don't let them distract you. You really heard everything you needed to hear today from Dr. Andy Little, an independent expert in this field. Dr. Little talked to you about the standard of care and what reasonably careful doctors would have done had they seen the intake form that Judge Kangas filled out. He talked to you about Viagra and explained the dangers of Viagra when coupled with a heart disease and how in Judge Kangas' case, it is absolutely what caused his death. Dr. Little talked about the fact that if he had been there, he or any other reasonable doctor had seen the intake form that Judge Kangas filled out with every single one of these red flags, including heart disease, low blood pressure, chest pains, dizziness, fainting spells, and most importantly, erections lasting longer than 4 hours, a condition that can only be brought on by taking Viagra, he would have taken notice and immediately warned the judge and said, "Judge, you gotta stop taking Viagra. It'll kill you." The defendant admitted to you today that she didn't do that. She only vaguely remembers seeing Judge Kangas at all. And she chose to ignore every single one of these red flags. And because she ignored every single one of these red flags, she caused Judge Kangas' death. These are your jury instructions. This is the law you have to follow today in determining whether or not the defendant's negligence caused Judge Kangas' death. You know by this point that it did. Now, we as the plaintiff had the burden in this case. We had the burden of proving to you by a preponderance of the evidence, meaning more likely than not, that the negligence of Dr. Hammer in failing to warn Judge Kangas of potentially deadly drug interactions caused his death. We have met our burden. We have met our burden because we have shown you both that the defendant was negligent and that her negligence is the reason Judge Kangas died. Negligence is the failure to use ordinary care, or the failure to do that which a person of ordinary prudence would have done under same or similar circumstances. By now, you know that the defendant was negligent for 3 specific reasons. First, she was negligent because she failed to read the intake form that Judge Kangas filled out. And even if she did read it, like she told you, she must have read it, it was part of her routine, she failed to notice what a reasonably careful doctor would have noticed had they seen that form at first glance. Second, the defendant was negligent because she failed to give Judge Kangas a proper examination and treat him for what he came in for that day, lightheadedness. And third,
The defendant was negligent because she didn't warn. She failed to warn Judge Kangas about the very drug interaction written all over that page that would kill him a month later. And because she did these three things, she proximately caused the judge's death. Proximate cause is a cause which, in a natural and continuous sequence, produces an event, and without which cause that event would not have occurred. For something to be a proximate cause, a person using reasonable care would have to be able to predict that that event would lead to the judge's death. There is a natural and continuous sequence between the defendant failing to warn Judge Kangas about a fatal drug interaction and then him dying of that very same drug interaction. It's that simple. But the defense tried to complicate things today by throwing out, like I told you, these red herrings. But the law allows you to decide which witnesses you believe in this case. You, as the jury, have the ability to choose to believe or not believe certain witnesses based on their credibility, based on whether or not their testimony was believable to you, or based on their interest in the outcome of this case. The defendant has an interest in the outcome of this case. More than everyone here, the defendant has an interest in the outcome of this case because ultimately, she's the one responsible for Judge Kangas' death. So when she told you, she was careful. She gave him a proper evaluation. You don't have to believe her. Keep that in mind now, and keep that in mind when the defense comes up and tries to explain away her negligence. Now, in fact, you don't have to believe any of the story that you heard from the defense today. The defense told you a confusing story of murder, love affairs, death, but ultimately, this story was nothing but a red herring, intended to distract you from the fact that Dr. Hammer simply didn't do the job that Judge Kangas entrusted her to do. So when they come back up here and they tell you that story again, remember the testimony of Ms. Cory Kangas, Judge Kangas' widow. Remember how she described to you what she found the day she found her husband dead in his chambers. He looked peaceful. He looked relaxed. Ms. Kangas didn't walk into a murder scene. She didn't notice any weapons, any threats. She didn't see any blood. She didn't see her husband collapsed on the ground. She didn't see her husband as a victim of someone who had been hit on the head. And that's because he wasn't a victim in this case. In contrast, we also heard from Stevie Walker today, who told us a confusing story about what she found when she went to the judge's chambers. She talks about a bruise on the judge's head, but we don't have any indication of why it was there, what it looked like, because ultimately, Ms. Walker lost all of the photographs that she took in this investigation, except for this one. We have no idea what else Ms. Walker found, why it was significant, and that's because there was no significance to anything Ms. Walker found. Oh, and by the way, Ms. Walker was recruited by the defendant herself to follow my client around town. You heard her say that. She was asked by the defendant to spy on Ms. Kangas. Remember, you don't have to believe the testimony of Ms. Walker. And what you should take away from this is that you can't believe the testimony of Ms. Walker. Now, we also heard vaguely about this person named Kelly Taylor. I just want to point out that we don't know anything about Kelly Taylor. Stevie Walker doesn't know anything about Kelly Taylor. Kelly Taylor is just another red herring in this whole case. Now, it doesn't matter that the judge's visit to the defendant took place a month earlier. That very visit is the reason Judge Kangas didn't make it home to see his wife that night. It's the reason that he suffered from a fatal loss in blood pressure, as we heard Dr. Little confirm to you. And it's the reason that he died. And the defendant should have known that this would happen. This was foreseeable. The second she saw that intake form, she should have taken notice that he had been taking Viagra, that he had heart disease. But instead of taking the extra minute, the extra 6 seconds out of those 6 minutes that she spends with her patients to say, Judge, I noticed that you take nitroglycerin and that you have erections lasting longer than 4 hours. Don't take Viagra, it could kill you. She didn't do that. Instead, she brushed the judge aside as quickly as possible to maintain her routine, her pace of 6 minutes apiece, 10 an hour, 120 a day. You heard the defendant admit to you that she knows what Viagra does. She knows that if coupled with certain medications to treat heart disease, can be deadly. And you also heard that it's a fact that Judge Kangas, at the time of his death, had 30 milligrams of Viagra in his system. And you know that he had heart disease. He had a heart condition that was extremely serious. You heard the defendant admit she knows what those things mean. But then you also heard her victim blame. You heard her say, the judge didn't tell me, so it wasn't my job to tell him. Folks, let me ask you this. Why does anyone go to a doctor at all? If you wake up in the morning and you have a sore throat, you know you have a sore throat. You might not know exactly what it means, so you go to the doctor to make sure it's nothing worse. You go to the doctor to be prescribed proper medications, to be told which ones to avoid. You go to the doctor to be told things that you don't know if you don't have a medical background. Judge Kangas was lightheaded the day he stopped by the defendant's clinic. Judge Kangas had a serious heart condition, and whatever he was feeling on that day was urgent enough that he didn't wait to go see a regular doctor. No, he needed help now, so he went to a walk-in clinic, and he relied on the help of a licensed physician to give him that help. But he didn't get that help. Instead, he was left in the dark, unaware and unwarned of the deadly drug interaction that would kill him a month later. By telling you today that the judge should have known to tell her what he was taking, what was going on, even though he did indicate it on an intake form, she told you herself she didn't use reasonable care. Because it is not reasonably careful to assume that patients with no medical background at all know these things, know things that doctors with specialized knowledge, with years of education know. A reasonably careful doctor would have double checked. A reasonably careful doctor would have checked in the first place. A reasonably careful doctor would have warned the judge. Now, in the time that I've been up here talking to you, the defendant would have been through 2 patient visits right now, and on to her 3rd. In the time I've been up here talking to you, the defendant would have introduced herself, read intake forms, evaluated the patient, physically examined the patient, diagnosed the patient, explained that diagnosis, came up with a treatment plan, explained that treatment plan, come up with medications to prescribe, checked the safety of those medications, checked the side effects of those medications, explained the medications, and sent that prescription off to the pharmacy twice. That is a relentless pace to keep 120 times a day. The defendant can't remember all of those steps, and she didn't remember all of those steps when treating Judge Kangas. Now, in a minute, you're going to go back to a room, and you're going to be handed this form. Question 1 on this form says, did the negligence, if any, of the parties below proximately cause the death of Rob Kangas? Next to Dr. Jody Hammer, write yes. Write yes because she was negligent in not checking, not double checking, and in failing to warn Judge Kangas about the same drug interaction that would kill him. Next to Rob Kangas, write no. He was the patient. It wasn't his job to be his own doctor. If you do this, if you write yes next to Dr. Hammer and no next to Rob Kangas, you're done. You do not have to go on to question 2. However, if you do write yes next to Rob Kangas, give him 1%. Give him 1%
for not understanding the complex interactions between drugs and heart disease. Give him 1% for not paying attention every time an ad pops on TV or reading the fine print in a magazine. But give Dr. Hammer the other 99% for not doing her job. In a minute, defense counsel is going to stand up here and try to explain away the defendant's negligence and throw out all those red herrings that we just talked about. And when she does that, don't forget the facts. Don't forget the fact that Judge Kangas walked into a clinic with lightheadedness and left with a sore throat. Don't forget the fact that you, members of the jury, have the ability to choose which witnesses to believe based on their interest in the outcome of this case. And don't forget the fact that no matter how defense counsel tries to explain away her negligence, explain how little time she spent with patients, how little time she spent with Judge Kangas, the defendant always maintained a routine, a habit of 6 minutes a patient, 10 patients an hour, 120 patients a day. Hold the defendant responsible for what her relentless pace and careless practice led to. Hold her responsible for the death of Judge Rob Kangas. Thank you.
Closing argument for the defendant.
Yes, Your Honor, if I may have 1 moment.
You may.
One moment, Your Honor. Apologize for the delay.
Your Honor, so the remote isn't working, so if you don't mind, I'm just going to sit here and help run the slideshow.
Absolutely.
Thank you.
So you guys are learning one very important lesson. It's not a real trial unless you have a technical issue somewhere.
Do you want to just proceed with that one?
I can just continue with that.
Okay.
Thank you. May I proceed, Your Honor?
You may.
This is a case of many questions. Questions without answers. What happened in the court chambers the night that Judge Kangas died? We don't know. Was anyone with Judge Kangas the night that he died? We don't know. Did Judge Kangas die from a drop in low blood pressure? We don't know. This case is a tragedy. The loss of a loved one, a community member, a husband, and a friend. On June 7th, 2008, Judge Kangas was found in the court chambers with a bruised and bleeding mark on his head. After conducting a complete investigation and an autopsy, it was found that Judge Kangas died from blunt force trauma. And now, in a search for closure, fingers are being pointed without sufficient evidence to find blame. Now, the plaintiff has the burden of proving to you today two things. First, that Dr. Hammer was negligent. Negligent for failing to warn Judge Kangas about the possible interactions between taking nitrates and Viagra at the same time. And second, that alleged negligence was the proximate cause of Judge Kangas' death. Now, before I talk to you about what it means to be negligent and how to establish proximate cause, I want to talk about what it means to prove something by a preponderance of the evidence. You see, the plaintiff not only has to prove both of those elements, she has to prove it by a preponderance of the evidence. And that means more likely than not. Now, that may seem like an easy burden. But at the beginning of trial today, the plaintiff began at 0%. 0. And through the course of trial, the plaintiff had to present enough testimony and enough evidence for you to find a 51% chance likelihood that not only was Dr. Hammer negligent, but that alleged negligence was the proximate cause of Judge Kangas' death. I want you to think of the game of dominoes. A domino here represents a single percentage of likelihood. In order to find that Dr. Hammer was negligent, the plaintiff has to line up 51 dominoes. Proximate cause means in the natural and continuous sequence of events, from treatment to tragedy, from April 27th all the way to June 7th, that Dr. Hammer's actions were foreseeable and directly linked to Judge Kangas' death. Not only does the plaintiff have to stack 51 dominoes, at the end of trial, all those dominoes must fall together. But as we've seen in the testimony today, that there's more than one cause of Judge Kangas' death. We've heard conflicting testimony about drops in low blood pressure, blunt force trauma to the head, and it's your job as a jury to determine whether or not the plaintiff has stacked 51 continuous dominoes. We started trial today hearing testimony from the plaintiff, Cory Kangas, the wife of Judge Kangas. You heard her mention how concerned her husband was of having a heart attack. So concerned that he changed his lifestyle. He stopped working out. He stopped doing strenuous activities. He carried nitrates on him at all times. But you heard that wasn't the only fear in Judge Kangas' life. You heard that Judge Kangas worked trying criminal cases in a dangerous line of work. And that on the morning of June 7th, when Cory Kangas walked into the court chambers, they were unusually unlocked. This fear, a fear of a heart attack, Why was that fear not mentioned to Dr. Hammer? We don't know. You heard from Dr. Hammer today that it is her routine habit and practice to review all medical history forms that are filled out by patients. That she relies on her patients to accurately and completely fill out those medical records. That is an urgent care operator. She sees patients for one reason, that singular reason that the patients come in, and that it is her job as somebody specializing in diagnostic medicine to identify that issue, to talk to the patient about that treatment, and to make sure that it doesn't conflict with any of the medications that the patient listed on the medical report form. You also heard today from Dr. Andy Little, an expert in the field of erectile dysfunction syndrome. And you heard that he based his findings on autopsies, toxicology reports, depositions by Stevie Walker and Cory Kangas. You heard that he relied on an autopsy even though he believed it to be sloppy. Why was it sloppy? You heard that Dr. Little conducts intense research into autopsies and the causes of cardiological deaths. And you heard that the cause of death cannot be accurately determined without the careful consideration of blood chemistry. And then Dr. Little referred to this autopsy report. The toxicology report, the traces of nitrates weren't even quantified. Allegedly, Judge Kangas died from a drop in low blood pressure from taking nitrates and Viagra at the same time. And an expert stood on the stand today and told you it is his definite opinion that Judge Kangas died after reviewing a toxicology report that wasn't even completed. But the autopsy was completed. You don't need to dissect a heart to find that somebody died from blunt force trauma to the head. Blunt force trauma that you heard Stevie Walker, the investigator in this case, saw with her own eyes. That when she walked into the court chambers, she saw Judge Kangas in the chair, blood and bruise on his head, a trophy on the ground. A red herring? The autopsy report found that Judge Kangas died from blunt force trauma. Now, in the burden today, we have to talk about negligence and whether Dr. Hammer was negligent. But the plaintiff has failed to prove sufficient evidence that Dr. Hammer spent 6 minutes or less with Judge Kangas. How long did Dr. Hammer spend with Judge Kangas? We don't know. Why did Judge Kangas not tell Dr. Hammer that he was taking Viagra? Dr. Hammer asked. She asked clearly, please list all medications you are currently taking. And the medications that Judge Kangas lists, Viagra wasn't there. You heard that Judge Kangas came to see Dr. Hammer because he was lightheaded.
And you heard that Dr. Hammer took the time, asked the questions, checked Judge Kangas, and determined what was making Judge Kangas lightheaded. And that within those 5 weeks, from when Dr. Hammer saw Judge Kangas to Judge Kangas's death, that there were alternative causes. Viagra does not cause blunt force trauma. A trophy next to the body of Judge Kangas. The plaintiff has failed to meet her burden. She has not stacked 51 dominoes. She has not shown by a preponderance of the evidence that Dr. Hammer spent any less than the sufficient amount of time to treat Judge Kangas for why he was there. And in showing that from treatment to tragedy, that Dr. Hammer was foreseeably or directly involved in Judge Kangas' death, there are more questions than we have answers. It's understandable to want closure, to seek answers to the questions that we still have. It is not acceptable to find someone liable for a harm they did not cause. The plaintiff has failed to show that Dr. Hammer was negligent, and that that negligence was the proximate or even direct cause of Judge Kangas' death. We ask that you find Dr. Hammer not liable for Judge Kangas' death. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor.
May I proceed? Defense counsel just came up here and told you that we have more questions than we have answers for. So folks, I'm not going to spend a lot of time up here, but I do want to go through some of the questions that we still have and the answers that we have. First of all, defense counsel talks about a trophy. Where is it? We don't have a trophy in evidence today. We don't have a murder weapon in evidence today. Second, we don't know anything about blood on the judge's head. You heard from Stevie Walker. Stevie Walker didn't know anything about this trophy. She didn't have any evidence of blood. We all saw the photograph that Stevie Walker did have. And in that photograph, we can't conclude much. We can't conclude that the judge looks like he'd fallen asleep in his chair. So those are some questions that I still have about what the defense counsel is talking about. But I want to go through some of the answers that I have for you, some of the facts in this case. We know for certain that at the time of the judge's autopsy, he had 30 milligrams of Viagra in his system. We know for certain that the expert that you heard from today, the one expert, Dr. Andy Little, testified to the fact that he, as a reasonably careful doctor, would not let any patient with a heart condition have any more than 25 milligrams, and that any more than this could be deadly. We know for certain that it could be deadly with the other drug that was found in Judge Kangas' system, nitrates. Sure, it wasn't quantified, but it was there. We have proof, we have facts, we have data on an exhibit that nitrates were there. We also know for a fact that Dr. Hammer didn't talk to Judge Kangas about Viagra. We know for a fact that Dr. Hammer didn't ask Judge Kangas about his erections lasting longer than 4 hours. We know for a fact that Dr. Hammer did not spend enough time with Judge Kangas. Those are some of the answers today to what happened. And ultimately, it boils down to the fact that on that autopsy report that defense counsel talked to you about, there is another cause of death listed. And that cause of death is a fatal drop in blood pressure. The evidence that we heard today, the facts that we heard today answer that question. What can cause a fatal loss of blood pressure? Viagra, nitrates, heart disease. Those are clear answers. Everything else you heard was a distraction. Hold the defendant accountable for what we know. What we know she didn't tell the judge on the day he was in her clinic. Hold her accountable for the death of Judge Kangas, because those are the answers that we have to work with. Thank you.
Thank you, counsel. Anything else before we go off to deliberate? All right, we will be at recess. Thank you.
everybody. I have to say, this is my first time doing judging for a mock trial, and it has just been an absolute delight to watch each and every one of you. You're all immensely talented. I can't believe 3 of you are second-year law students. And I was telling Justice Moore and Judge Baki in the back that I would be delighted to second chair a trial with any one of you tomorrow. So very, very well done. We did have to pick one winning team and one winning advocate. The winning team is the plaintiff team. So congratulations. And the winning advocate is Nick Severson. But Justice Moore and Judge Baki provide some additional comments too.
Go ahead. Great. So I've actually judged and competed, been doing this judging since I was a prosecutor. So I've seen lots of these competitions. I will say that this is the best one I have ever seen, and I've seen a lot. So you all should be very, very proud of yourselves, even though you did not win. The 4 of you are amazing. And I want to speak to some of the high points. I know you don't want a lot of this, we need to move on, but you have great confidence, your eye contact, really all of those things that other lawyers currently do not have, many of them, you already have that base. I just wanted to, a couple things so you can not have a habit, and it's Stevenson?
Yes, sir.
One thing I want to point out to you is when you are doing cross, you have a habit of, and if you continue that, it'll be even harder. It's like muscle memory.
Okay.
I get why you're doing it, but you got to be really careful because you're very young. You got a long career ahead of you. You do not want to develop that as a habit. At this level, it's like just the small things. You do such really good work. I just want to remind you on photographs, it's irrelevant kind of who took the picture and when, as long as the witness can say it's an accurate portrayal of what I saw. One thing you want to keep in your toolbox, one of the best exceptions to hearsay is the effect on the listener. That's your biggest one, is effect on the listener. What did you hear? Objection, hearsay. Based on what you heard, what did you do? Then what did you hear and why did you do? You see what I'm saying? That's a great one to keep in your toolbox. And I thought you did a great job on your close without the technology, and you have to be prepared for that. I think my colleague here made a very good point. In this day and age of technology, you better be prepared that it's not going to work and be able to recover. I thought you did an excellent job of doing that. I could imagine the PowerPoints that you had, and I just thought in my head probably what was there, and you did a great job. One thing, and I forget your name.
Phoebe Schneider.
Ms. Schneider. There's a difference between saying, I believe the evidence shows, and a difference between saying, I believe the defense will say. I don't care what you believe. It's irrelevant what you believe, except for, I believe the defense is going to say this. Then it's relevant, because you're saying, I think they're going to go down this road. But for you to say, I believe the evidence, just tell me, the evidence says this. And that's one habit that I see a lot of attorneys get into is they keep saying, I believe, and it's like, you just tell me what it is, and that's all you need. Almost done here. I thought your side did, one thing you really want to do, if you're going to do rebuttal close, you write down, you take notes exactly what they've said. And you did a great job counteracting what their theme was. Their theme was there's lots of questions. It's like, well, heck yeah, there's a lot of questions. Let me just tell you what those questions are. So great job on doing that. Rebuttal close is like the funnest part, I think, of being a trial attorney, is you get to take everything they just said and you get to just throw it up against the wall and show that none of it will stick. So anyway, those are just some small things, but keep in mind, you're kind of the best of the best here, and there's really not much more to say. Don't lose heart that you came in second. My goodness. Yeah, you guys were excellent. Thank you.
And I thought all of you were just outstanding, and you should be so proud of yourselves. I'm amazed because you're still in law school, and I was telling my colleagues that you guys are better than some of the lawyers
who appear in front of us. So you've got a lot to be proud of. Just a couple of things. I really liked your opening statement, Mr. Steverson. You have a pleasant way about you that I think is very likable, and I think juries will like you and I think trust you. And you can't put any value on that. I mean, I wrote down that I really liked these Tully's closing. I thought it was excellent too. And you did it, as was mentioned just a moment ago, without the ability to use the PowerPoint because it didn't work. And you didn't let that fluster you. You said I can do it without it. And I was watching you try to see if it would take you off your game, and obviously it did not. And so kudos to you for having the poise to go through it. Let's see, Ms. Schneider, I really liked your cross of Stevenson, your cross of Walker, Stevie Walker. Walker gives you a lot to work with. And, I thought you did a nice job. And by the way, the witnesses did a really great job too. We were talking back there. We really liked Dr. Little in particular. Even with the glasses, putting the glasses down a little bit and looking at the report. And I thought that was very cool. And Dr. Hammer was great. Everybody was great. Dr. Hammer was really great, so anyway, I thought Ms. Schneider did a really nice cross with Walker. And then for Ms. Murphy, you have a presence about you, a command of the room when you're in action. And man, I don't know how you have that at this level, but you do have it, and it's great. So, and I can tell that you feel at home when you're doing your thing out there. And in fact, when your witness wasn't here, instead of freaking out, you cracked a joke. And that's great, because you know what? In trial, that happens. And jurors are human beings, just like you. And, a joke like that, the jury would have laughed. And so you got to do that and be yourself and have a sense of humor and when appropriate, it's okay to do something like that. And I thought that was very appropriate. And in fact, I think you had a couple of funny comments in there, and it was perfect. And so rather than have us annoyed at you, you made us like you more. So that was spot on, yeah. So all of you guys, kudos to all of you. I just can't say enough good things about all of you. I am just so proud to be here to be able to do this, and just so impressed with all four of you. So congratulations to all of you.
Do you guys have any questions?
Thank you all so much for your time.
Yeah, thank
We
you
really
so much.
appreciate this.
It was a lot of fun. So fun to watch. Yeah, and the witnesses made it that way. You guys can make and break these. So you really get some extra kudos. You help your team tremendously. That's what makes it fun. So thank you.
Thank you immensely for taking the time. It's appreciated on a late night. And of course, thank you witnesses as well, both sides. It was greatly appreciated, and we know what an effort this is.
Thank you all so much, and congratulations, you guys.
Great
Great
job.
And thanks to CU for hosting this great event, and Michael, you and your family, this is a phenomenal thing that you're doing.
Make us proud.
Thank you for coming.
Thanks, Evans. You too.
Yeah, thank you for doing this. This is really a great thing. Thank you.
All right.
We're at recess. Thank you.
Thanks, everybody.